Good evening, ladies and gentlemen, attendees and participants. Welcome to the October 10th meeting of the City of Tampa Variance Review Board. From my left, the members of the board are
Brian D. Fry.
Sam Decker.
Brett Feldman.
Anna Walrapp.
Also in attendance this evening from Legal, Susan Johnson-Velez. From Development Coordination, Mary Tavares. And Laura Marley. From Natural Resources, Stephen Eister. From Land Development, Josh Blackman and Lisa Middleton. There are some procedural rules that we need you to follow. When your case and petitioner's name are called, please approach the podium. When you approach the podium, please state your name, address, and confirm that you've been sworn. The petitioner or its agent will have 10 minutes to make a presentation. All other persons or participants wishing to speak will have 3 minutes. Then the petitioner will have an additional 5 minutes for rebuttal if needed. Time periods, as stated, will be kept by the board. Any information, such as pictures or plans that have not been previously submitted as part of the petition and that you intend to submit for consideration in support of your petition, must be individually presented and accepted by the board. After acceptance by the board, you must submit the item to staff for it to be entered and made part of the permanent record. The board bases its decision on competent and substantial evidence which is submitted and which meets the criteria required by the city's Code of Ordinances. Please be sure to clearly state your hardship criteria during your presentation. A majority of the board is needed to approve your variance. The variance granted by the board will only be for what is shown on the site plan and must be in compliance with any terms or conditions stated by the board. All other city codes must also be met. If the case is approved, your variance will expire 2 years from the date of the decision. If your case is continued, it will either be continued to the next month's VRB board agenda or to the next available position on an upcoming VRB board agenda. If your case is denied, you may wish to have the Variance Review Board's decision appealed to the City Council. You must file a petition for review of the board's decision within 14 days of the board's written decision. You will not be able to pull any permits until the 14-day review period has passed. Your cooperation in ensuring that the meeting is run smoothly is greatly appreciated. Please also note that at this time there are only 4 board members that are present. That does constitute a quorum. However, under our rules, an applicant has the right to continue their matter until there are a minimum of 5 board members here. We expect a couple of our board members will be a little bit late, so if your application is called and you wish to defer it until the end of tonight's agenda, please ask when you come up to discuss your application. Can I have a motion to approve the minutes from the September 12th BRB board meeting?
I was gonna say,
Oh,
we
you're
have
right.
2 meeting minutes. We have the August meeting minutes that we need to approve and the September ones, which was just
Excellent. Good point.
not here. So if you'd like a motion, can we do that in one motion, Ms. John? Simple as? Okay. I will move to approve the August, what was the date of those? August 8th.
Yep.
August 8th, 2023 board meeting minutes and the September 12th VRB board meeting minutes.
Second.
Thank you. All those in favor say aye. Any opposed? All right, the meeting minutes are approved for August and September. At this time, I will ask legal staff to confirm whether there are any ex parte communications or conflicts of interest.
Thank you, Madam Chair. At this time, I'd ask if any of the board members have had any ex parte communications with anyone with respect to any item on the agenda this evening. Seeing none, I would now ask if anybody, any board member has any conflicts of interest with respect to any item on the agenda this evening. Seeing none, thank you, Madam Chair.
Are there any changes to the agenda that staff wishes to address this evening?
Just the request for the continuance.
Okay. So should we go ahead and,
Which request, which?
this
one
is
was
for
that?
VRB 23-32.
Correct.
And is,
Yeah, it is here.
Okay. Well then, let's go ahead and conduct the swearing in, and then we'll go ahead and be on the record.
For all those who wish to speak or present this evening or give public comment, please stand and raise your right hand.
So anyone who could speak this evening, please stand to be sworn.
Do you swear to and affirm that you would tell the whole truth and nothing but the truth? Yes.
All right. So the first case is BRB 23-32. If you could just state your name, address, and confirm that you've been sworn.
Yeah, my name is Ernest Mueller of Mueller Law, PA. We are the, just came aboard as the agent for the applicant on this. My address is Tampa, Florida. We are requesting a continuance. We want to try and see if there's any administrative opportunities here that might affect what the variance request is. So we're requesting a continuance to December 12th, 2023.
Okay. And just to sort of cross all my T's and dot my I's, could you just confirm that you've been sworn?
I have
realize
been
that
sworn.
Okay, thank you. Okay, is there anyone in the audience that would like to speak on this requested continuance? Right, seeing none, is there a motion by the board to continue this case?
Sure. Madam Chair, I will move to continue VRB 23-32 for property located at 5610 North River Shore Drive. They are requesting continuance to December 12th, 2023. I move that we continue to the 5:30 p.m. hearing that day.
All right, motion by Mr. Feldman, is there a second?
Second.
And by Ms. Walraff, all those in favor say aye. Aye. Any opposed? None? All right, we will see you in December.
Thank you very much.
All right. Ms. Marley, if you could give us the background on VRB 2322, please.
Yes, ma'am. VRB 2322 is property owner Daryl and Kelly Smith. The agent is Colin Rice. The property address is 3322 Sierra Circle. It's RS 75. The variance request is reduce the front yard setback from 25 feet to a 0-foot setback for the construction of the pool per LDC section 27156. This is the aerial of the neighborhood. The property is outlined in red. Here's the front of the property. The front yard setback is to the right of the subject house. This is the site plan. It is a little busy. where it says proposed 34-foot by 19.5-foot envelope, that is the area of the pool. It is meeting the setback on Sierra, but not the setback from South Herpestein Street. Thank you.
Hesperides.
The development review comments, natural resources consistent with conditions, right-of-way is consistent with conditions, TICO is consistent, transportation consistent, wastewater approved, stormwater has some comments that will be addressed in the conditions. And then this is just the standard for the variance review board. These are 5 criteria that the VRB has to take into account when granting or denying the variance request. And this is the answers that the applicant gave. They're quite lengthy, so I won't read them. They have been in the packet. And then if the VRB approves this variance, the following conditions are required. 1, a design exception must be applied for to consider the 6-foot wall that is proposed on the site plan that's around the pool. 2, development should comply with the City of Tampa Stormwater Technical Standards, Chapter 21 of the City of Tampa Code. 3, the current flood zone information, including FEMA firm and date, must be added to the site plan. And 4, the site will comply with chapters 5, 17.5, 22, 23, 26, and all technical standards of the City of Tampa, and chapter 27 unless waived specific to this request. And I'll put the site plan back up for the VRB.
Thank you. Is the applicant here this evening? Just confirm your state your name, address, and confirm you.
Sure. Good evening, Colin Rice, the law firm of Older Lundy on behalf of Daryl and Kelly Smith. My address is 1000 West Cass Street, Tampa, Florida. I have been sworn. I do have some slides I'll show, if those are visible.
Lisa's coming to help.
Thank you, I need help. Okay. Okay, great. All right, so good evening again. Appreciate staff's working with us. This has evolved somewhat over time, so we're happy to be with you this evening with what we feel is a strong proposal. Really for the installation of a pool in the only portion of this property that could reasonably accommodate one, and I'll get into the details here. So the specific request is relief from section 27-290.3 to permit the installation of a swimming pool 0 feet from the western lot line where distance of 25 feet would otherwise be required. So I'm showing you from section 27-161 of the city code. Diagram 5.1 depicts this type of corner lot. When you have 2 street frontages, you are considered to have 2 front yards and 2 side yards. By definition, this property does not have a rear yard. So what I have here on the left is from the original plat back in the 1920s. We are lots 37 and 36. And to the right is an aerial, and I've added FFFSS to signify front and side yards so that you can see how that definition is applied to this site. So now and I apologize for the busyness on the site plan, but there's a lot to go through here. So again, we have the pool here in blue on the western side of the lot. 25-foot component of the request, of course, in RS 75, we're required to maintain a 25-foot front yard setback, beyond which becomes side yard. We physically don't have the space to accommodate that, and that's the relief sought this evening. I do want to highlight that we have an abnormally large 30.2-foot right-of-way between the property line and Hesperides Street. We will have to remove one protected, not grand, but protected tree. But in the interest of mitigation, we've committed to providing a new replacement oak tree north of the pool and constructing an architecturally consistent 6-foot brick wall along the pool area. With respect to the staff report, we'll reiterate, as had been mentioned previously, that natural resources, right-of-way, TICO, transportation and wastewater have no issue with this request. But to address stormwater again, and I'll put this back. We're cognizant of the technical manual requirement to retain stormwater on site when you exceed 50% impervious. And we've actually engaged an engineer. There'll be an engineered underground stormwater solution installed under the driveway at great expense. So rest assured at development, this will be compliant with the technical manual. We're fine with all the other proposed conditions. So showing you an aerial map, just to give you a little better context of the neighborhood. Our subject site is in red. The green check marks signify neighbors who we've interacted with that have no issue with this proposal. So those closest to this installation are fine with it. We're grateful for that. And we have had, considerable community outreach. Wanted to make sure, people get this letter in the mail. It might be a little confusing. So we held a virtual neighborhood meeting on September 6th, attended by 2 neighbors. Nobody had any issues. Again, proactive contact with neighborhood associations is possible. I'm not aware of any opposition unless somebody's here this evening, where we've had support across the board. And now for everybody's favorite part, I'll be thorough but efficient as possible. So the alleged hardships are unique and singular to this lot. Again, it's a perfectly square lot, 115 by 115, with 2 frontages, and it has no rear yard. Southern side yard includes substantial plat life, and it is very close to the setback, as it is considered side yard. It's not appropriate for a pool. Again, the plat was from 1926. And that's really how this became a corner lot, and many, if not most, of the dwellings in the vicinity are able to enjoy in-ground pools. Sub 2, this hardship is not the result of actions of the applicant. The applicant did not plat the subdivision, did not design the site, did not construct the home, did not determine the tree locations. It's not self-imposed. Sub 3, this won't substantially interfere the health, safety, welfare of others. In fact, those closest to this proposal are all on board, fully aware, and have no issues with it. Again, we will plant a replacement tree. We'll provide this 6-foot brick wall. And again, we do have that abnormally wide 30.2-foot right-of-way between the property line and the street. We're in harmony with the comprehensive plan, which encourages creative urban development, encourages the retention as best you can with respect to vegetation. We do have mature vegetation on the south. So we feel we've met the comprehensive plan goals and policies. And this will ultimately result in substantial justice being done. Again, encouraging preservation of existing mature plant life, preserve architectural and aesthetic consistency, and grant the applicant a property right commonly enjoyed by the vast majority of other property owners. So to conclude, these folks have really done it the right way. This was submitted, I believe, in January, February of this year. So it's been a long process to reach this point. They've engaged arborists with dark moss to ensure appropriate treatment of the vegetation on site. There has been a redesign of the pool to avoid any potential encroachment on a shared city tree. It is smaller than originally proposed. They're committed to the replacement tree, the 6-foot wall. They've hired a stormwater engineer to account for the retention, held the neighborhood meeting. And so just to wrap up, we feel we've met all of the variance criteria. Remember, this lot does not have a rear yard by code. We do have the abnormally wide right-of-way, and we have extensive outreach, and we're pleased to have support of the neighborhood that we've been in touch with. So with that, I'll conclude. Happy to answer any questions. We respectfully request your approval this evening. And, oh, I'm sorry, I'll submit these slides into the record.
Thank you. Does that complete your presentation?
It does, thank you.
For anyone in the audience who would like to speak about this application? All right. Seeing none, I'll open it up for board questions.
Mr. Rice, do you happen to have a site plan that doesn't have all of the other stuff on there? I'm trying to understand, you've got a bunch of stuff covered up and I'm not sure what's really,
I do.
what's what.
I'll submit these, I don't want to forget that. And then I do have a site plan I'll show you.
Okay.
Talisa. Thank you.
I can zoom if you'd like anywhere.
No, it's the same one we've
No,
got.
it's a little better.
Well,
It's got a few less.
yeah, I'm trying to find out, see where you've got this proposed underground? I wanna know what's under that.
So typically, the way these work is they're big, and I apologize, I'm not a
I'm not
stormwater
asking
engineer.
about the stormwater itself, I'm asking on the site plan where you've got that little green sign. I wanna see what's under there as far as on the site.
Currently, that's the
Uh-huh.
driveway.
I'm sorry?
That's the driveway to the home.
Well, I see all kinds of different things underneath there and I can't figure out what's what, so that's why I'm asking.
So this, oh, under the actual sign?
Yes, sir.
I'm so sorry. This is the rear of the primary structure. So this is the edge of the single-family home, and this is the back small deck courtyard
Okay.
area.
So the side yards, so where it says lot 37, and then there's like a little skinny strip there. What's the dimension there at the, between your house and the property line?
Here,
Nope, little skinny strip.
this.
Yes, sir.
Oh, my eyes are failing me. I'll pull this up for a moment.
Yeah, I can't,
I can't see it.
it's not.
I know the required setback there is 7 feet. I believe
Right.
it is close to 7 feet, but I apologize, I can't read that figure.
Okay. And then across the back, all the way down at the bottom there.
Mm-hmm.
Yeah, what's that? Is that 7?
This is, I believe that
Looks like
says
7
7 feet
feet.
9 inches.
Mhm. Okay. And then there's a little rectangle that's just kind of free floating there. To the right, to the, well, it's kind of in the middle.
Here,
To the, yeah, keep going, that's it, yep, what's that rectangle right there?
this is the air conditioning unit.
No, sir, it's big, big.
This
That-
is, this,
Yes,
a little brick paver area.
okay. So there's no structure on there, just pavers,
Pavers and vegetation back here, yes.
okay. All right, thank you. And, oh, can I ask one more question? So the fence, the brick wall that you're going to put in there is gonna be inside of the property line also?
Correct, close but
Within the-
inside of, entirely within the property, yes.
Okay. Sometimes brick walls will have, stuff on top of it, those lovely pineapple things, and just wanna make sure that that's gonna be within the property lines.
Fully compliant wall, yes.
Okay.
With the design exception as noted in the conditions.
Okay, thank you.
You're not planning a screen enclosure?
No, sir.
Could I see the satellite image once more, please?
I've got it.
Yes.
This one?
Yes, thank you.
Okay.
You know approximately how many other homes in the neighborhood currently have a swimming pool?
I would be guessing, I don't have an exact number for you.
Okay. Thank you.
And did you consider even like a 1-foot setback? I understand your hardship and all, but down to 0 is cutting it pretty close. I mean, a 1 foot would make a heck of a lot of difference. You wouldn't have to worry about, oops, I measured wrong kind of stuff.
Fair
That-
point. Oh, I'm sorry, continue.
No, that's always something that comes up in future issues.
Sure, fair point. I'll offer that this did shrink somewhat and to have a viable, shrink in consideration of the shared city tree to protect the root structure. So with that shrinkage, they wanted to give themselves the ability to go out this far. It doesn't mean at the end of the day they will build out that far. It's just giving us the allowance of that space. I'm confident, they'll add some margin there.
Okay. 25, 24 point? No, just like, I don't know. And how wide is the pool?
Hey, could you give us the dimensions of the pool again, please?
I'm just
30
looking before I put it too
I see it, never mind, I see it.
Okay.
Oh, I see, okay.
34 by 19. Has there been any consideration to make the pool smaller?
It was made smaller. It was made smaller. You mean smaller than proposed now?
Yes. That's a large pool.
In width.
I think as proposed, it is a relatively small pool area, and so in consideration of bringing it down from the north, they had already shrunk it to some degree. Unfortunately, the clients unfortunately were able to be here for September, but they're committed tonight, so I'm unable to ask them that question this evening.
All right, any other questions from the board? All right, you have 5 minutes for rebuttal should you need it.
Okay. I'll just add one point that I should have mentioned previously. Across the street, this is association-owned property that's undeveloped and will not be developed. So just want to reiterate that those within the immediate radius of this site are all supportive. So, we feel this is appropriate. We've come a long way with working with staff. We think this will be a welcome addition to the neighborhood. Really appreciate your time this evening. Thank you.
Right, that I'm going to close the public hearing and open it up for discussion or motion from the board.
So here's my dilemma on this. I mean, the fact that there's so much stuff on here that they have to do something special with the groundwater is rather concerning. It's South Tampa, which, the most minute rainstorm floods everything everywhere. And I'm not real fond of a zero, cutting setbacks to zero. I realize this is not a huge pool, but it's still a good size one, given how much space it's taking up in the yard. I want to hear what you guys have to say. Convince me otherwise.
So I don't disagree with you. As far as the stormwater is concerned, the stormwater department has made arrangements with the homeowner and has gotten comfortable with the proposal. So I don't, I'm not comfortable sort of second guessing what stormwater does. And I hear your point about putting up the wall. Listen, zero lot line is, concerning. I hear your point about sort of accidentally building over the lot line. Really, my concern with the zero lot line is, okay, what if the city wanted at some point to expand the right-of-way? The road would come up right next to the pool, but again, I don't really feel like that's my decision to make. I wouldn't want to swim in a pool that was next to a road, but, I'm not sure that really weighs on my decision to grant or deny this variance.
And my point was only going to be this. I generally agree that the 0 foot is not great, but they do have a pretty big buffer next to them. So it's not like there's an issue with maintaining the property right along that line. Like oftentimes when we see the rear setback 0, we're like, there's no way they can maintain anything. Water's gonna go right over that and into the neighborhood property. And as far as the stormwater issue, they're dealing with it. They haven't crossed the 75% green space threshold. They're still at 50%, right? So to me, my position is this: look, people deserve to have a rear yard, and corner lots don't necessarily get that. I don't know when they acquired this property, whether they built it, whether it existed like that. My guess is this house has been here for a while, just like this for a while. And to me, letting them have a rear yard, even though it ends up kind of looking like their side yard, we've seen a lot of these, and it happens. So I'm okay with it. We can dicker over the size of the pool a little bit, but it seems consistent with the neighborhood. It seems like, given the location, it's burdening the fewest number of people.
Okay.
So that's my perspective.
I have one more question for the city. So if this is a front yard, there's a height restriction on fencing in front yards, and it's 36 covered up or 48 with openings. Correct. So how is that apply here?
That's why there's a condition number 1 that they must apply for a DE1 to be considered. Not saying that it would be granted, but staff would, when the applicant submits the application, staff would review the, like the area, the subdivision to see if it kind of fits in with it, and they would either approve it or deny it or work with the applicant, but this is not to say that it would be granted, because for an opaque wall, it would be 3 feet would be the max.
Right.
Right, so the 6-foot brick wall that they're proposing as a buffer, it's not really our decision to make that. They're not applying for that this evening.
Correct.
Okay. It's a good question, though.
Well, I just want them to be aware that we're not able to control that, so what happens after the case leaves here, you know, you may get a 4-foot wall around your pool, not an 8.
You can't, not for safety.
Well,
There's also the safety.
understood, but,
We just have to be see-through.
yeah,
Be, I believe, 6 feet.
All right.
okay.
So let's do this. I'm willing to make a motion and see where it goes.
Okay.
If I can find my motion. There we go. Oh, I'm sorry. Before I do that, I don't know if this is for the city or for legal, but the stormwater condition, do we need to include that in our motion, or is that going to be addressed at permitting?
Yes, I have, my slide asked for if you were going to approve this variance, the 4 conditions that are required. So if you would make your motion with the 4 conditions that staff has read into the record, that would be appreciated.
Okay, can I reference the 4 conditions, or do I need to, this is more for legal, I guess. In my motion, do I need to read out the 4 conditions? Because if I do, I'm gonna need some help on that.
I think you could say with conditions as noted in the presentation by staff.
Perfect, that's what I wanted to
Okay.
hear.
They are also in the staff report.
Okay.
They
All
are,
right,
and-
awesome.
yeah.
I move that the variance request for case VRB 23-22 for property located at 3322 Sierra Circle, as depicted on the site plan presented in the public hearing, to reduce the front yard setback from 25 feet to 0-foot setback for the construction of a pool, with the encroachment for eaves and gutters, be approved with the following conditions: that the applicant at permitting meet the 4 conditions included in the staff report and read by staff at the city hearing. That said variance as conditioned be granted upon the applicant presenting competent and substantial evidence in the record and at this public hearing of an unnecessary hardship or practical difficulty when considering the 5 hardship criteria set forth in section 27-80 of the city code, specifically that the property is a corner lot, that due to the corner lot platting, the property has 2 front yards and 2 side yards, and that in order to be able to use a rear yard, this is the only way to do it. It is also the means that burdens the fewest neighbors because it is placed next to the street. The street has a large 30-foot buffer between the new setback and the street, and that the applicant, though moving a tree, is replacing that tree. Well, there is no screening being applied for, and the applicant noted no screening is being requested.
All right, we have a motion by Mr. Feldman. Is there a second?
Second.
Second by Mr. Fry. All those in favor say aye.
Aye.
Those opposed? All right, your motion is approved 3-1 for your application.
Thank you very much.
All right, and before our next variance, just want to note that 2 other staff members, Todd Foltz and Aaron Murphy, board members, have arrived.
Did you see it? No? You don't see it?
Don't see it yet.
It should be. It's showing here.
It's showing there.
Mm-hmm. It's showing here.
Okay. I'll start, hopefully Ivan puts it on the screen.
Okay, 'cause
The next variance is VRB 2325. The owner is Broad Sky Milana Properties. The applicant is John Lum. The property address is 3010 South Esperanza Avenue. The zoning is multifamily RM16. The variance request is to just decrease the front yard setback from 25 feet to 8 feet and the rear yard setback from 15 feet to 3 feet for the construction of a single-family, semi-detached residence with allowed encroachment of the eaves and gutters, per LDC section 27156. Here's an aerial of the property. Here it is outlined in red. Here's just a view of the property, but this is from November 2019. Again, 2019. Here's the site plan. As you can see, there are 2 lots and it's semi-detached. Again, this is another rendition of the site plan. Development review comments, natural resources is consistent, transportation consistent, well, natural resources consistent with conditions. Grand tree noticing was never completed. The grand tree removal noticing will be required to be completed and mitigation for the tree will be assessed based on the TRE assessment and added to the building permit. So that's all at building permit. Transportation consistent, right away, consistent with conditions that the applicant has filed the ROE, which is release of easement 2310. So that would need to be approved by city council. And then TCO is inconsistent. They couldn't really tell what they were referring to as the front yard, and they were worried about an OSHA clearance. I have contacted the applicant, and I believe the applicant will address this. Again, just the standards for the VRB, the 5 criteria. The applicant has answered these. 1, the hardship or practical difficulties are unique and singular with respect to the property and its proximity of the crosstown off-ramp. 2, the hardship or practical difficulty does not result from the actions of the applicant. This is not a self-created hardship or practical difficulty. 3, the variance, if granted, will not substantially interfere or injure the health, safety, or welfare of others. 4, the variance is in harmony with and serves the general intent and purpose of this chapter and the adopted Tampa Comprehensive Plan. And 5, allowing the variance will result in substantial justice being done, considering both the public benefits intended to be secured by this chapter and the individual hardships or practical difficulties that will be suffered due to failure of being able to develop this property. If you have questions for the applicant, they can expand on this. And then staff comments. If the VRB approves this application, the following conditions are required. 1, the release of easement, application ROE 2318 must be heard and approved by the city council. We don't have a date of the application going before city council before construction commences. 2, the issues with TCO must be addressed before construction commences. 3, the grand tree noticing will need to be addressed, but it will be added to the building permit. And 4, the site will comply with chapters 5, 17.5, 22, 23, 26, all technical standards of the city of Tampa, and chapter 27, unless waived specific to this request.
All right, is the applicant here? Just a reminder to state your name, address, and confirm that you've been sworn.
Steve McElhaney, 2407 Sunset Drive. Yes, I have been sworn, and I'm an authorized agent for this project. This previously was approved, and the variance was approved back in 2015. I think you have that in your package. It was, through the course of a divorce, it was held up in the courts for the settlement for quite a while. This is a new owner who purchased the property and thought that the variances were still intact, and they soon discovered after they went in for clearing and permitting that it wasn't. This is an aerial photograph showing you the off-ramp of the crosstown, which dramatically affects the development and buildability of this site. This is another picture of, and you can, I think you can, let's see. You can see the crosstown guardrail right back here. This is the off-ramp, and you see the property here. It's cut off at an angle right there, and then this is Esperanza, and the proposed single-family homes will be facing Esperanza. So technically, if you had, according to the code, to measure the property by its narrowest width being the front, it would be the crosstown if they had access there. There's a grade differential there of about 8 feet between the crosstown and the grade level of the property down below. There's another photograph of the crosstown. I have a site plan showing you that this property is, this is the rear yard setback that's being requested, and it's continuous all the way across. This is the front yard setback that's being requested, and there's only those two structures that face Esperanza, and these two back up to the crosstown. So there aren't any other properties that are affected by this. With consideration to the conditions that are being requested, we've contacted TECO. They had a concern about overhead lines, and we have submitted an application and committed to undergrounding those service lines so that there will not be any conflict. They had a safety concern about the proximity to the structures. With respect to the easement, there was a previous easement that was established on this property that is inconsistent with what is done on this property, what's being proposed. And that application for the release of easement has been submitted, and there will be new easements required for TECO that'll be submitted at the time of permitting. With respect to the tree that was removed, there had a permit and an approval to remove the tree, and apparently through the staff's research, they determined that the process was not finalized. I don't know exactly why it wasn't finalized, but I suspect that it was because of the divorce settlement that encumbered the property. The criteria regarding the request for the variance. All the other departments had found that this was consistent, and they had no objections with the exception of the conditions that we asked for. The alleged hardships and practical difficulties are singular to the site. I believe I've demonstrated that with the Crosstown Expressway impacting the site and the property lines being affected and cut off to the extent that it affects the buildable area. The hardship and practical difficulties do not result from the actions of the applicant. The plat was already established, the Crosstown Expressway was already built, and this does not, it has not been done, and it wasn't done by the applicant. The variance if granted will not substantially interfere with the injury of the rights of the health, safety, and welfare of others. It can't, the two properties are adjacent to each other, and the setbacks being proposed are identical. The variance is in harmony with the general intent of the code and the comprehensive plan. The proposal never meant for a site to be underutilized. This would utilize the site in compliance with all of the other codes that are required. And as the staff has pointed out, we still have to comply with the other building codes and the other technical standards. And then we're committing to doing that. The variance will be in substantial justice being done. It will enable us to restore a previously approved variance and to establish the development and building pattern that we've proposed that would not be interfering with any of the rights of others or other surrounding properties. Allowing the variance with the substantial justice to be done, and we're agreeing to the conditions that are being suggested by the staff. We believe that we have met the criteria regarding this specific proposal. As I said, this is a new owner, and the fact that some of the issues were carrying over from a previous granting of a variance was not their fault, and they're trying to reestablish those rights that were previously granted. I respectfully request your approval and be happy to answer any questions.
Thank you. Does that conclude your presentation?
That concludes my presentation.
Right. Is there anyone in the audience that would like to speak on this application? Right. Seeing none, I will open it up to the board for some questions.
I'm having trouble getting it. So are these two separate lots that you have here? Do you have two parcels in
One's
one
already-
lot? What is going on here?
They're trying to build a single-family residence. One of them was already built. This one is built.
Okay.
This one, they're
It's
trying-
already built with the setbacks that are being requested.
it was previously approved and built to those setbacks.
Right.
This is the vacant lot that's adjacent to it, and they're proposing to duplicate the same setbacks.
Okay, but we need it was the first lot, and either legal or staff help me out here. The one that's already built, is that approved, or are we approving that this evening?
That was already approved.
Staff, confirm? That was
They
approved?
did have two other variances that were approved, so if the building
And they
is,
hadn't expired, this is good?
I mean, if it's already built, they were built under the previous variance.
Okay,
So they're just gonna match what's been done at the.
Right.
Okay.
Their intention was that the couple that owned it were going to live in this other parcel, this other lot, and because of their condition, it never got built.
When was the other one built? When was the first one done?
I believe in 2015.
Oh,
oh, all right, that's helpful.
mhm.
All
When
right,
the original variance was granted.
all right, so that's helpful, thank you for explaining that. The next piece I'm having trouble, or concerns about is we have, yeah, it's an unusual lot, absolutely, odd shaped, stuck next to the crosstown, great to try and make use of, this unusual property. But the idea is to put it as close as possible to this off-ramp. Does that not present safety concerns? Is that not a concern for anyone who's,
It's an elevated roadway.
great, so when the car comes through the window, because it's 8 feet off the ground, no concern there?
But to confirm, we're not granting the setback here, but I guess
Right.
the crosstown. Right.
We're being asked to give a 15 to 3 feet on the rear yard setback. So,
But there's still a buffer there, the crosstown still owns more property besides that, between the rear yard and the edge of the pavement.
okay.
There's at least another 25 or 30 feet. The guardrail that I showed you, from this photograph, there's still another 25 feet or so between the edge of the pavement and the guardrail. And then there's another, at least another 10 feet between that guardrail and the end of the property line. It's almost, I'm estimating now because I don't have the exact measurement, but I think it's about 45 feet between the property line and the edge of the pavement.
All right, those are the questions I had for now.
So, excuse me, I'm sorry, but I just want to clarify. So the staff report indicates that the variances were granted in '06 and 2018. So if that's something that's important to you all, I don't know if you wanted to have more information about, I know there was testimony that the existing house was built in 2015.
That's my mistake. I'm in the existing house, the other house on the inside. I was looking at the ordinance, which, or I'd say it says 2018, I'm sorry.
So what I see from the map here is that it looks like there were, if you zoom in, maybe 2 townhomes just south of it on 2016 and 2018 on Esperanza.
Went across the street, you
Well, no,
know?
on the same street, but to the right. of
Yes,
it.
further down, there's townhomes.
So there's 2 townhomes there, and then this looks like it's gonna be 2 more townhomes.
Well, the proposal was for a single family, but a single family attached. So they do have some commonality to them, but,
Well, I mean, it looks like they split the lot into parcel A and parcel B, is that correct? It's lot 9.
But so just to be clear, we're only approving, you're only building 1 unit here, right? It's.
yes, we're
Okay,
not
so
building.
unit 2, as we're looking at it in our packet, already exists. Unit 1 is what you're proposing to build.
Correct.
Are you sure about?
That's why it's not real clear in this packet.
It appears that these 2 units are not built yet, that the ones to the south of them are built.
It's the one further to the north that is being proposed for construction.
Correct, but it appears the one that's to the south on the split lot is not built yet. For everything I can tell.
I mean, the renderings make it appear that
That they're both,
it would be unusual to just have built half of this, but, you know, that,
well, and so it looks, and I'm looking at the map here. Do you see a house on that bottom
No,
piece?
I don't
I see a tree there. But, I mean, so that's my question, is, are you looking to build 2 units in this property now, or is 1 unit already built, and you're looking to build a second one to match it? Because it looks, from our packet and from the information we're seeing, that maybe nothing exists, and they're looking to build both of them.
Well, the request was for a single-family semi-detached dwelling with the allowed encroachments.
But that appears to be inconsistent with the site plan that was provided.
I'm sorry, see, I didn't,
That appears to be inconsistent with the site plan that's in the packet.
well, what I have is the same site plans that you have.
maybe does staff have a photo of the,
So,
like, notice sign?
There are 2 site plans, one for each lot. One's grayed out, and then the other one's grayed out.
Yeah.
There's a unit 1 and a unit 2. So there are 2 site plans.
So on that plan that you're showing right now,
This one,
This is the property, right?
that includes both of these units.
Yeah,
unit two is already existing. Is that true?
no, that's the problem. We're not sure.
So I wanted, so is this house what he's talking about now?
That's what you got.
Yes.
You got this built already. And then we'll go to right here. Yeah.
Mr. Michelini, can you tell us, are they wanting to build 2 units or 1 unit?
The information I have is 1 unit, semi-detached.
Okay, because that's inconsistent with what's in front of us right now.
Yeah.
And looking on the property appraiser's website, it seems that there is not currently a unit on that property.
When did you become authorized agent for this one, Mr. Michelini? Recently?
Recently.
Yeah.
Yes, yes.
Yeah, so, yeah, and that's, our staff report seems to be suggesting that there are 2 units being built. And the initial concern I was having is, we're really jamming a lot onto this little property. Why are we building 2? If the information is, oh, well, one's already built and we're just matching it, okay, I guess I can understand that. But if both are not existing, which I think is what's occurring here, then I have to ask the question, why are we jamming why are we jamming as much as we possibly can onto these 2 small lots in this unusual location?
I can only, default back to the fact that it's a multifamily zoning lot. And you could, it's not a single-family lot. You could have the 2 units built there.
You had a plan earlier that showed, I think maybe in yellow, where you were saying that this was the existing setback and we're just going to match it?
I believe that was the case.
Okay, so, I think that you have a couple,
I think that
I can think of a couple options here. The first one is that we could go ahead and move forward with, making a building on your variance, but I'm not sure that that's gonna do your client a whole lot of good if they can't build the lot next door, or, the unit next door that they're anticipating. If, in fact, the request is for the setbacks for both units, I think that we probably need to do something different with the notice here. Legal is.
Why don't we, let me make some phone calls, continue this for a while. I've got the next case as well, so if we could just continue this case, and depending on whether or not I can get a hold of somebody else, it may be necessary to continue it to next month, but just so I can get, just so.
It would be 2 months, but do you want to just take a pause on this and come back later? We'll
Yeah,
put you at
let's
the
try
end.
that for now, please.
Okay.
Okay, then I'm going to ask for a motion to just move this agenda item to the end of the agenda.
All right. I will move to move VRB 23-25 for property located at 3010 South Esperanza Avenue to the end of our hearing agenda this evening, so that we can allow the applicant to get some more information to answer some of our questions.
Okay, motion by Mr. Feldman, second by Mr. Foltz. All those in favor say aye.
Aye.
Thank you. I think we need to clarify the site plans as well, because they are kind of confusing. I appreciate you.
Pictures are different too.
All right, so let's go ahead and move on to 2336. Are you presenting for us tonight?
I am presenting for you guys tonight. My name is Stephen Eister, Natural Resources. This case VRB 2336, the property owner is Melinda Pletcher. The applicant is Steve Michelini. The property address is 2912 San Rafael Street. The property is zoned RS 50. The variance request is to remove a grand tree to construct a new single-family home. The grand tree falls under section 27-284.2.5. which is the reasonable reconfiguration criteria, not the hardship criteria. This is the outline of the property here. You can see San Rafael, and then that it's fully canopied. The grand tree in question is a live oak, 34 inches, with the canopy measurements 63 by 65. The condition is C6. The mitigation for this tree would be 15 type 1 trees at 2.5-inch DBH. These are some photos of the tree in question. You can see the yellow bungalow that's there that has been demoed. They received a demolition permit for that due to some structural issues caused by the tree itself. There you go. This was the existing site when they bought it, so it was a 1,100 square foot house. The current condition of the site is vacant. There's nothing there existing. So this is the proposed floor plan. It's a 2-story, 35 square foot with a detached garage set back off the property. This preserves a grand laurel in the rear yard, which is shared with the alley. So if you guys see that small green hash line in the back of the property, that's another grand tree. That one was rated C9, so it's still in viable condition, and it shouldn't really be impacted by the construction. This is alternative site plan 2. This house is about, I want to say, 15 foot wide, and then it just kind of runs back the length of the property there. The base square footage of this house is 950 square foot, and there's no detached garage. You can see it does move out of both protective radiuses. This is alternative site plan 2, which is 1,273 square feet, no detached garage again. It preserves the grand tree, but then you end up with that kind of U-shaped design to get that square footage. This is the criteria for grand tree removal under 27-284.2.5. And then if you guys have any questions or concerns, you can ask me, but currently there are no other objections to this variance. And Natural Resources is consistent with conditions.
Okay. Thank you very much. And Mr. McElhaney, I think you're the applicant on this one as well. You have 10 minutes.
Steve McElhaney, I am here representing the Plesher family and their request to remove a grand tree. As the staff has pointed out.
Address and that you've been sworn.
Steve McElhaney, yes, I've been sworn. In the staff report, they've indicated that with the 3 alternate plans and designs that were presented, there's only one that they thought was reasonable, and that resulted in a single-story, 950 square foot house, which for the area and for the development pattern in Palma Seca is highly unlikely. The staff had no objections, and we had filed an arborist report as well. The house did receive, the property did receive a demolition permit because of the extensive structural damage that it caused to that house, which was according to the engineers, and I'm sorry I don't have a letter for you, but it was beyond reasonable repair. We also noted that, personally noted that the property adjacent to it on the west side had also started to experience some structural difficulties. The lot is, at least the location of the tree is in the middle of the lot, which creates the kind of problem that we have with the location and the development of the property. And I will show you the alternate site plans. And these also are in your package. This is the proposed development on the site. These other two were the proposals, were the alternates that were submitted to the staff for their consideration. This is the only one that they considered to be viable. There was another petition that included removing that grand tree back there, but that was removed from the application, and we were planning to preserve that. So the criteria under which we're being reviewed is the impact of the proposed building structure area on the impacted area shown by a survey and a drawing of the parcel accurately depicting the location, crown, and spread. This particular tree has a very large spread, and it sits right in the center of the lot, as I said, and it's impacting both this property and the other property. At permitting, it may be required that we'll use pervious pavement as well as grade beams to protect the, I'm sorry, that tree we're proposing to remove. Normally, you would have to have grade beams to affect its safety. But in this case, the spread is all the way into over here. You can see the dotted line. The proposed building and structure will be reasonably configured as defined in table 284.2.5, and we did that with the alternates that were being proposed. And the result was that it was not a reasonable reconfiguration that resulted in a viable redevelopment of the site. The reduction of the required setbacks of the primary building as provided in section 27-156, table 4.3, dash note to allow the relocation of the building structures sufficient to preserve the grand tree as requested for removal. We did that with these alternate plans, and the result was that it could not be reasonably reconfigured. The alternate construction methods utilized to preserve the grand tree requested for removal up to the critical root zone. And again, our arborist as well as the city staff determined that that was not reasonable. The cost of utilizing an alternate construction method and the relocation and the use and value of the proposed building to save the tree compared to the tree condition shown in the hazard evaluation form. And that was all submitted to the city, and the staff found that we could not reasonably do that, considering that the result was a 950 square foot home, single story. For any removal applications or necessary accessory buildings, new construction and/or building additions, the board or the commission shall also consider the existing development pattern and similar necessary accessory buildings in a radius of 1,320 feet. Only the properties that are within the same zone district shall be used to consider making that determination. What's being proposed is reasonable, and it is consistent with the pattern of development within the 1,320 feet. Again, I'll bring you back to the staff letter, which is looking at the alternate site plans, only option 2 would not propose serious conflicts to the tree, and the site plan shown preservation of 3 with 950 square feet due to the canopy of conflicts as a second story would not be added. So that creates a significant hardship for the property owner, and I believe that we have met the criteria as established by the code. We've looked at alternatives. The staff has reviewed it, and as you know, that's a critical eye. That's not something you easily pass on without their approval. So due to the setbacks in the lot and the variance proposal, shifting the home in one way or the other does not save the tree without extraordinary expense and difficulties. So we're respectfully requesting that we be allowed to remove the grand tree while proposing to meet all of the mitigation that was required for that site, which is the 15 trees as pointed out by staff and also by our arborist. You have those reports in your file. That concludes my presentation. I'll be happy to answer any questions.
Thank you, Mr. McLean. Is there anyone in the audience that would like to speak on this application? Okay, you have 3 minutes.
My name is Caroline Bennett. I have been sworn. I am a founding member of TTAG. Every 5 years, expert scientists compile a study of Tampa's urban tree canopy. The most recent one that was finalized, the report was finalized this year on data from 2021, shows that for the 10-year period from 2011 to 2021, the tree canopy in Tampa was reduced by 12.8%. That is, in the report, they say that is the equivalent of 4 Davis Islands. That's how many trees we've lost in that 10-year period. Our shade area of Tampa has decreased. Now it's at 30%, which is the critical amount that is accepted in the scientific community. The mayor was very alarmed by this and has committed to preserving our tree canopy and protecting it. She has conducted numerous interviews on television. She is committed to planting 30,000 trees by 2030. She is committed to prosecuting illegal tree removals. This is a high priority for this administration. The removal of a non-hazardous live oak is rare, that can be justified. They are the workhorses of our canopy. They represent 3% of the canopy, but they do more work than all the others. They are solid gold infrastructure, and they have become rare. We must preserve our grand trees. And like I said, it's rare that a non-hazardous live oak should be removed, but this case is the rare exception. I've spent a lot of time speaking with the City of Tampa foresters about this. I researched it, I looked into it, and I support this petition to remove this tree. It's not something you're going to see me do very often, but looking at all the facts, this is the rare, non-hazardous grand oak that does need to be removed. So I ask you to vote yes on this. Thank you.
Thank you very much. Is there anyone else who would like to speak on this application? Seeing none, I'm going to open it up to the board for questions of the applicant or staff.
Well, after we ask questions. So if you.
Seeing no questions from the board, you have 5 minutes for rebuttal should you need it.
No, well, it's unfortunate that the tree is where it is. The good news is that that report also talked about replacement trees, which will be put in a location where they will not create hazards and structural damage to other homes. I appreciate the support from Carol Ann Bennett. I know she's tough on these issues, but we sat on the same board to try to figure out with the tree ordinance when it was revised to figure out how best to approach tree removals and tree replacements. So in that respect, we appreciate that, and we'll look forward to the tree replacement as requested and required by the city. And thank you. I appreciate your support.
We're not there just yet, but thank you. All right, I'm going to open it up for a motion or discussion from the board.
Yeah, it's a beautiful tree. I hate to see it go, but I don't see any other way to develop the lot or replace the house, which is clearly not a good house. This happens, I agree, it happens to be the one case where it's just unfortunately in the middle of the lot, and there's no way to work around it.
So is there a motion there?
Sure. Does anybody else want to discuss, or? Okay. All right. I would like to move the variance request for case VRB 2336 for the property located at 2912 West San Rafael Street be granted as depicted on the site plan presented at the public hearing for for a removal of,
Slippery entry
Oh, at the
at the
bottom.
very bottom.
okay, I apologize, I'll start again.
Yep.
I move that the variance request for a case VRB 2336 for property located at 2912 West San Rafael Street be granted as depicted on the site plan presenting the public hearing for removal of a grand oak tree based upon the petitioner meeting the burden of proof with regard to the 6 factors determined as tree removal and set forth in section 27-284.2.5 F4 of the city code for granting tree removal. Specifically, that the evidence provided in the record showed that the lot was unbuildable with the current location of the tree.
All right, got a motion by Mr. Foltz, or second?
Second.
Second by Mr. Fry. All those in favor say aye.
Aye.
Any opposed?
Thank you, board.
You've got a good read on us.
Yeah, okay. But you can't be right.
Can I ask a question of staff? So on the agenda today, on 2336,
It says residential single-family home here,
yes.
but on the staff report, it says 8-unit townhome? That's a big typo.
That's a big
Okay. All right.
I had it marked and then I got the presentation but it is for just the single family.
Thank you.
Good question.
Well, yeah, startled me when I
Yeah.
saw that.
Guess not what we heard.
VRB 2344, property owner Charles Gaines and Carson Fisher. The applicant is Charlie Gaines. Property address is 6214 South Elberon Street. Zoning is RS 50. The variance request is to reduce the rear yard setback from 5 feet to 3.8 feet and the south yard setback from 5 feet to 3.6 feet for a screen pool enclosure per section 27-90.5. Here's the aerial of the property outlined in red. Here's a view of the front of the property. And here's the site plan, and there you can see the pool cage. LDC right away. The applicant has filed a ROE 2335, and Stormwater has approved the release of the stormwater easement reserved over the vacated alley. Natural Resources is consistent with conditions, and Stormwater is consistent. Here's the criteria of the variance 1 through 5. The applicant responses to the criteria. And if the VRB approves this variance, the following conditions are required. 1, the release of easement application ROE 2335 must be heard and approved by City Council. We do not know a date of the City Council meeting before construction commences. And 2, the site will comply with chapters 5, 17.5, 22, 23, and 26, and all technical standards of the City of Tampa in chapter 27, unless waived specific to this request.
All right, thank you. Is the applicant here?
Yeah.
Come on up, and just a reminder to state your name, address, and confirm that you've been sworn.
Yes, my name is Charlie Gaines. I am the property owner at 6214 South Elbron Street, and I have been sworn. So our request is to reduce the rear yard setback from 5 feet to 3.8 feet, and on the south side yard setback from 5 feet to 3.6 feet for a screened-in pool enclosure. To start, I'd like to read the statement that I prepared that summarizes our hardship. So my wife and I bought our South Tampa home 2.5 years ago. The property featured a backyard with a pool and hot tub, but no pool enclosure. We quickly realized, just a couple of months living at the property, that raccoons and other wildlife often visited the pool in the backyard. This led to significant raccoon issues. We utilized a pest service to trap and remove the raccoons, but they were not able to trap them. Turns out that raccoons are pretty smart. And back in May, we finally reached the end of our rope, and we called a pool enclosure company to get a quote. And they came out and they started measuring, and they said, "Sir, your hot tub is is within that 5 feet required setback, you'll have to reach out to the city and request a variance. So I called the city permitting office and discussed applying for a variance, which brings me here. The huge safety concern with these raccoons is for some reason, they like defecating and swimming in my pool. After conducting a lot of research, we learned through the CDC that raccoon feces can contain a parasitic worm called, I'm gonna try my best on this one, Balysacaris procyonis, which is extremely harmful to humans, particularly for children, and can cause severe neurological illness. Unfortunately, chlorine and filters are not able to rid of this parasite, and the only way to know if a raccoon tests positive for the parasite is by sending a sample of the stool to a lab for analysis. And after that stool has been in the pool, it's very hard to bag and get out to the labs. Our biggest concern is safety for our family and friends. We have a 6-month-old boy named Henry, and his safety is our top priority. Every time a raccoon defecates in the pool, we have to drain it, clean it, and refill it. This makes the pool not usable for weeks at a time. Adding this enclosure will ensure the raccoons or any other wildlife can't have access to the pool. I have a few exhibits that I'd like to share. Let me see here. So we're fortunate to have a Ring camera set up in the backyard, and we were able to capture the thief in the act. So this is our backyard, that's our pool, that's the raccoon, and that's actually him after doing the duty. My next exhibit is we have tried multiple defense mechanisms against these raccoons. We've set up chairs over the top step so they couldn't get in. We tried laying other various stuff around the border so they can't get in, but they swim pretty well, so they find a way. And they like to knock down whatever we put over the top step into the pool. This exhibit is my son. He's the reason why I'm here. I want a pool enclosure so it's a safe environment for him to be able to swim, and he is learning how to swim now. And then my last exhibit is the CDC information that, I'm not going to read through all this, but it basically speaks to what that parasitic worm is and why it's so dangerous in pools. I think that's everything that I've prepared to present to you guys tonight. I'm happy to answer any questions. We feel like we've followed all the appropriate steps to get this variance completed, and we really hope that you approve this for us.
Thank you. Is there anyone in the audience that would like to speak for or against this application? Seeing none, I'll open it up to questions from the board.
I have a couple of questions. I think these are for staff. So question one, there's a lot of information about tree removal in our packet, but that's not something that's being requested tonight. What's going on with that? Maybe Mr. Eister can explain that to us. We've got an arborist report. It matches to the address too, so I was thinking maybe it got attached to something else. But no, we've got arborist reports for 2 tree removals.
Yeah, so Stephen Eister, Natural Resources. My first set of comments before the consistent with conditions comments, you guys see, I saw the 2 large trees in the rear yard, so I requested the arborist report. And after the arborist report was provided with their conditions, I was okay if they had to be removed based off that. So that's why it has been changed, and I think there's also a tree removal permit on site, separate from the screen enclosure.
Okay,
So that's why.
So no variance, nothing we need to do
Nothing for
with tree
trees.
removal.
That's why the comments were changed to consistent with conditions.
Okay.
And that they have to just meet the natural resources requirements at the time of construction.
Okay, thank you, that
Yeah,
helps.
no problem.
This second question is for, I think probably Ms. Marley or perhaps for Ms. Johnson-Velez. Can someone tell me what our rules require as it relates to the site plans with measurements and things like that? Because as much as I like a cool marker-drawn pool cage, I just want to make sure we're doing what we need to do and we've met the rules on that.
What's required is a site plan to scale that shows the measurements to scale. The applicant has asked for the 3.8 and the 3.6, so they will be required to meet those dimensions when the screen enclosure is constructed.
Okay, so the site plan that's in our packet meets the rules?
Does it have the
Just,
measurements?
I just need
Can
confirmation.
I make a
See.
quick comment? Is that allowed?
I mean, yeah, I don't, that's fine. I don't know if you're gonna be able to answer the
Well,
question, which is.
they reached back out to us and said we needed to submit an updated site plan.
Okay.
And through Acela, we did submit, the pool enclosure company did a full render, like everything. And that's uploaded into Acela, which
Oh.
shows all the measurements that I described.
Okay. Is that something you could put up
I,
on this?
you
Not
know, I wish I
not
had
you.
it in my
You don't have
packet.
it. Is that something we?
It's uploaded into Acela. That's why I giggled when I saw the first one, because that was my first stab at showing you what I was trying to do.
Yeah, I'm not bothered by it. I just want to make
Yeah.
sure it complies with the rules.
Now, we got a professional one done that was overlaid on the boundary survey that we had done at the property when we purchased it. So there is one that's uploaded that's more professional than the scribble.
Do we have what we?
Staff would have to make sure, but the request is for 5 to 3.8 and 5 to 3.6. So at time of building, they would have to show that. So at time of building permit, they would need to show that site plan with those measurements on it.
Right. I agree with that. I just want to make sure that we have complied with our rules. I mean, if he's got something submitted, then he's done what he needs to do. So I just want to make sure if you can confirm that that's submitted and we have what we need, then we can move forward. If that's all I'm asking.
Okay, we're pulling it up right now.
Awesome.
I'd like to also quickly state that the measurements that we are proposing are the minimums that we need to get the pool enclosure in that space. So we didn't extend it any more than we absolutely needed to fit the pool enclosure.
Yeah. My wife also yells at me for my great ideas. This one, just 2 words for you, raccoon catapult, just a suggestion.
Hey, I'm for it, but I believe they're endangered, right? So you can't touch them. I'm not gonna do that.
Darn. All right.
Are they endangered?
I don't know. It seemed like
I maybe threatened. Maybe threatened. I believe they are in South
threatened by
Tampa.
a catapult.
We were really surprised that there's so many, and we still get them today. Last night I had one doing backstrokes in my pool. So, and we started this process back in May, and we're hopeful to move forward from here.
Well, I don't have any other questions. Voila, compliance.
Yes, that's the updated one. Thank you very much, sir.
There you go. Okay, great, done.
All right. Anyone else have a question for staff or the applicant? Seeing none, I will close. Seeing none, you have 5 minutes for rebuttal should you need it.
I don't think I need it. Thank you,
Okay,
ma'am.
we can close the public hearing, open it up for discussion or motion.
I move that the variance request for case VRB 23-44 for the property located at 6214 South Elberon Street be granted as depicted on the site plan presented at the public hearing for a reduction in rear yard setback from 5 feet to 3.8 feet and to reduce the south side yard setback from 5 feet to 3.6 feet for a pool enclosure based upon the applicant presenting competent and substantial evidence in the record and at this public hearing of an unnecessary hardship or practical difficulty when considering the 5 hardship criteria set forth in section 27-80 of the city code, specifically that the applicant did not create this hardship. The pool and jacuzzi were existing, and Mother Nature has created a whole lot more of hardship. This will not affect the health, safety, and welfare of the public. It will provide a safer environment for their child when swimming in the pool in the future.
All right, a motion by Mr. Murphy. Yes.
Could you add the 2 conditions that staff read and was in the staff report?
Of course, I would also like to include the conditions as read in by staff on the staff report.
Second.
All right, second, motion by Mr. Murphy, second by Mr. Foltz. All those in favor say aye.
Aye.
Any opposed? None. All right, your variance is approved 6-0.
Excuse me, Chair, but before you open the next hearing, I think in discussing this with staff and looking at the conflicting site plans, I think it's probably in the best interest of everyone to continue VRB 2325 to December. So I'm respectfully requesting that.
Okay. Legal, are we good to make a motion to that effect at this time?
There's no reason for him to stick around. I'll make a motion.
All right.
I move that we continue VRB 23-35 for property located at 3010, right? I'm looking at the right one?
Sorry, you had 23-25.
25, sorry, 2325. To property located at 3010 South Esperanza Avenue until the December 12th, 2023, 5:30 p.m. VRB hearing.
Is there a second?
Second.
Second by Mr. Fry. All those in favor say aye.
Aye.
Thank you, Board. We'll come back with clearer site plans. Thank you very much.
VRB 2350, property owner 824 SDM LLC, applicant Mark Brenchley, property address 824 South Dale Mabry Highway, zoning is commercial general. The variance request is to increase the number of signs per building frontage facing a public street from 3 to 8, the allowable sign square footage from 237 square feet to 1,098 square feet, and to allow signs on building frontage not facing a public street for an existing commercial structure, per LDC section 27-289.3, B6A1 and B6B1. Here's the aerial of their property outlined in red. Here is the site plan, and here are some of the signs. Here's one example of a sign. Here is actually 3 signs. The one that wraps around the building is considered a sign. Again, the wraparound and then a sign. Another sign and the wraparound, and then a wraparound. Land Development Code Section 27-289, it's allowed, the property's allowed 1 building sign per street frontage, 1.25 square feet of sign per linear foot of building frontage. Based on the provided measurements, 61.9, 57.4, 29, 41.3, there is 189.6 linear foot of frontage, allowing 237 square foot of building sign. The applicant is proposing to increase the allowable building sign allowance to approximately 463%. The corner lots or double frontage parcel shall be allowed 1 sign per street frontage. The parcel is unique as it is triangular, and it does front Southdale Mabry and Henderson, and it's the intersection of those 2 roads with a cross of West Morrison Avenue. The standard condition of this site that would be on the approval letter if VRB decides to approve this is the site would comply with chapters 5, 17.5, 22, 23, and 26, and all technical standards of the City of Tampa, and chapter 27 unless waived specific to this request. Here's the variance application criteria that the applicant must meet. The applicant did provide justification to each, which they can go over. And that is the end of my presentation.
Thank you. The applicant here. And if you could just state your name, address, and confirm that you've been sworn in.
My name is Mark Branchley. My address is 3790 Beacon Ridge Way in Claremont, Florida. And yes, I have been sworn in. Can I ask a request to the staff to show how the how you came up with 1,098 square feet?
Why don't you go ahead and continue with your presentation, and we'll ask staff to get that together.
All right. Can I then give my calculations to you? These are all in the application, but I've just literally cut and pasted them all into one page. So you could see exactly my calculations. As they prepare their calculations, we could see the issue here.
Sure.
Thank you. And again, I need to restate, this is just literally cut and pasted from the 4 exhibits, each of the 4 elevations. And to give you some background, it was basically related about the difficulty of this site. I think most people in South Tampa are familiar with this very awkward corner site. It is very prominent, there's no doubt about that, but because of the angles and the constriction of the space, a viable and a reasonable sized building has been difficult to achieve. And so while for Foods, which is a meat and seafood market, purchased it, I also represented them with a design exception a year ago, where it was granted, where they granted the sign on this on the E2, which is on the northeast elevation, and they granted that because of the issues. It does not front a public street, which is one of the requirements for the sign code, but it is over their main entrance of the store, because it's the only location there could be a entrance close to a parking lot and so forth because of the narrowness of that apex of the site. And so that Wild Fork, this Wild Fork wall sign was approved in the design exception, as well as the other 3 Wild Fork signs. But that's as far as they could go without having the applicant come to the Board of Adjustment to go beyond what will be the constraints of a design exception. So what we're proposing on this northeast side, and it is the second call, or the second line on your handout. The canopy signs, the 6-inch high letters, you see that the total is listed there. And also the iconic flame, which is their brand, even though it's 6 by 6 or 36 square feet, if you take it all into a box, it is much smaller than that because of the literal calculation of the the banding that creates that iconic flame. But for the purposes of this, it is still considered 36 square feet. So, but it really isn't in reality that large. And so then, this next one is the southwest, which is facing down toward the corner of Dale Mabry and Henderson. As you can see on this one, they are allowed 71 square feet, but only 22 is proposed in this linear lettering or wording, the white wording on the architectural overhang, or some would consider it a canopy. Then this is the southeast, which faces more directly to Henderson, and you see they're permitted 77 square feet, and only 64 square feet is suggested here. Just a very small canopy-mounted sign at 1.71 square feet. And then the final one is the elevation which faces north and to the west, directly to Dale Mabry. So again, here's the site plan. This is the north and the west facing Dale Mabry. And 77.5 square feet is permitted. 78.45 is the total of this. So, so I struggled to see where staff came up with 1,000+ square feet, unless they determined one sign per elevation and boxed everything within that one sign. But the application is specifically for multiple signs and also exceeding the maximum square foot area of it. So I just wanted to make sure that the board didn't think that this applicant was that greedy, seeking 400 times the size of what would be permitted, because it isn't, it's not the case. In fact, as it's summarized on the bottom, 226.45 is allowed, and that gives no allotted square footage to that northeast elevation because it does not have frontage, and so therefore it does not, it's not granted any sign area. And then over to the right, the proposed variant signs total 302.62 square feet. And all the Wild Fork signs have previously been approved and they are installed on the property. So I'd like to show you the example of those overhangs or the canopy. This is what it looks like. It provides protection from the building. Also a great backdrop for signage. The one on the north, over the main entrance, is especially critical for shelter and to create some type of a buffer against the rain for people who are entering the building. And then here's the one on the east side or west side facing Dale Mabry, where the address. So this address is going to be almost identical to what is proposed on the white letters. So you can see the scale, you can see the great contrast, and so forth. Now, as was mentioned, each of these statement of hardships have been defended, but I especially wanted to read the number one, the statement of hardship. This highly exaggerated pie-shaped corner lot at the intersection of Dale Mabry Highway and Henderson Boulevard is unique. Hardships and practical difficulties for appropriate and reasonable development are obvious. The parcel has for many years been blighted and underdeveloped. With some difficulty, the Wild Fork Market successfully located the current building and parking lot on the parcel, but are suffering difficulties locating compliant and reasonable signage on the property because of the literal code provisions. The lot's configuration prohibits the siting of the building to meet traditional and desirable commercial design features such as the main entrance facing the street, parking lot, access, etc. So, any questions that you have of me?
We'll have an opportunity to do that in just a few minutes.
Great.
All right, does that complete your presentation?
It does, thank you.
Thank you. Is there anyone in the audience who would like to speak on this application? All right, seeing none, I'm going to open it up for questions from the board.
So that's a pretty big variance in what we have calculated versus what he has.
Yeah, yes, it is.
I'm sorry, I have to ask staff that. How did that come about?
I did have my sign reviewer go through these, and he gave me all the calculations. Basically, staff does box in the areas, so he did do all of the signs on all of the calculations, and he did come to the 1,098.
And,
So it's all boxed in. It's, all the banners are considered a sign. So it's the length of the building as well. So you've got the length of the building and the additional signs. So all of that together did come to that calculation.
Okay. And so right now, according to this, they have 3 signs and they want to bump it up to 8?
Correct.
All right, so which ones are existing? I mean, it's kind of hard to tell from all of these.
The 3 Wild Fork wall signs are existing.
Right, right.
So the banner is not on there now.
Right, the banner is not.
But the awning is there, the canopy, the awning is there, it's just, you just want to put the lettering on it.
That's correct.
Is that all you're trying to add?
And the one,
And the flame?
the flame. Yeah.
Okay, so just so you understand, this is my personal opinion on this. If you're coming in and asking for signage, the best thing you can do for me, at least, is show us what exists and tell us what you want, right? So that's all I need to understand is, you know, okay, I get it, there's mathematical calculations about how the wording is calculated and all that, but so all you're saying is you just want to put some letters on the band going around the awning, and you want to put the little flame up.
Yeah.
Great, thank you.
Other questions from the board?
How long has the store been open?
The design exception was granted in February, so it's only been open, I think, since May or April.
No, it's got to be, it's been there longer than that.
Then maybe a year in April. Yeah, okay, I'm sorry.
Okay.
Yeah, we've been working on this since, this variance since April.
Okay, and what is there different traffic pattern? Are you finding people getting lost, they can't see it? What's bringing this a need before us?
I wish Anthony could be here. He's the store manager. I asked him to come and present their point of view, and that is one of reasonable visibility, because everything comes to the apex on both Dale Mabry and Henderson. They're either stopped and are ahead of the building because of the location of the traffic light, and so they're interested in displaying the products and the services available on the site.
I mean, it's pretty well signed right now, as far as, I don't think anybody can, from every direction you can see Wild Fork, including there's a big monument sign on the corner of Henderson and Del Mabry. So you've got 3 building signs and a monument sign, which is of equal stature. I mean, and you're not asking to add any more Wild Fork, so you're just basically, what it looks like, aside from the flame, you want to add the listing of everything going on the banner. That's really what we're asking for. I mean, it's pretty bright and happy right now, so.
Just a quick question for staff. Anything that we're granting is tied to the site plan, right? So if this building collapses tomorrow and they need to rebuild it, they can't just put up 1,000 square feet of signage anywhere they want. They have to follow what existed at the time. Is that accurate?
They could, if they did rebuild the building, they could put up the signs that they have been requested, yes.
Only the signs as they've requested on the site plan, right? They couldn't, change their mind about this banner going around and put even bigger lettering somewhere else and other things like that, right? I'm just trying to say it's tied to the site plan, correct?
It is tied to the site plan, but if you wanted to condition it based on the renderings that you have seen, you can add a condition stating that.
You know, the site plan doesn't show the signage, the renderings do. I don't know that it's a condition.
Yeah, that makes more sense. You're right. Thank you. Better terminology.
That's a flame, huh? I thought it was just a water droplet.
All right, seeing no more questions from the board, you have 5 minutes for rebuttal if you need it.
I don't need it.
Okay, all right, then I'm gonna close the public hearing and open it up for a motion from the board.
Do they require a hardship for this variance? And they're saying their hardship is that they don't have visibility?
There's a hardship required for every variance. The board is not authorized to grant a variance without a hardship.
I mean, it's on an irregular corner. It's not like it's just straight old square corner. It is a funky pie shape.
Normally what we would hear when we look to signage, we would hear a lot about traffic patterns, we would hear a lot about visibility, we would hear a lot about all those other things. This is a very visible intersection. It's also one that you pass really quickly. I agree that it is signed fairly well. I also feel like what is being requested is not that big. It is not that big of a change. And to the extent that what I see is you have a franchise that has a branding, then they want to be consistent. And I don't really have a problem giving consistent branding, provided that doesn't go a whole lot beyond what the sign code allows. And I don't feel like this does.
And the sign stuff that we've seen like some crazy like LEDs.
Yeah,
flashing
and that's the other
things.
thing, right?
We're
We're
talking
not-
about letters that are banded that don't move. They're black and white.
Electronic signs have.
If you
have a
actually measure
different-
the letters, they only come out to 300 square feet, not 1,000 square feet. But I understand that we're basically
the whole
taking
thing.
the whole square area.
So that's, you bring up a good point. What's to change that from being an LED changeable?
Well, that's the
That's
point,
gonna be the
is that
condition per the site
if we
plan.
condition to the renderings.
So we have to condition a static sign then?
I don't know that we condition it to a static sign, but if we condition it to the renderings.
The rendering could depict.
The renderings.
The rendering depicts, I mean, that's probably, I would say, a decal, correct? Are those decal? I'm guessing
Well,
those are decals.
there's probably block lettering, but they're.
Yeah, it's static.
I'm just saying you could read it both ways.
I look at this I mean, I've been by this building a million times, and I didn't know what it was till I went in the building, right? And I think this sign, allowing them to do this on that canopy is gonna probably give people a little hint as to what's going on in that building.
Yeah, you kind of have to be on top of it.
You do.
To read that stuff.
You do.
But
it's a lot.
Yeah.
So
I mean, you can see as you're, on this photograph, as you're driving by there, that anything you put on that band is not gonna be like in your face. It's not very big.
But if you're stopped at the light, you can read it.
Yeah, and that's why I'm saying, I
have no problem.
I really don't have a problem with it. I understand the purpose of the sign code, and I want to keep it to the sign code, but what I'm seeing here is just, hey, we want our branding to be consistent. And this will allow our branding to be consistent, and it doesn't appear to be like a massive overreach. So that's my opinion.
I have a quick question. What about like, typically you would put an applied sign in the windows? I don't think his picture showed, but I think the street view shows pictures of you know, their other offerings with what's underneath that. Maybe they're, would like to replace that.
Oh, I see what you're saying, okay,
And I like what they've designed much more than the pictures in the windows.
yeah.
So I
Yeah.
think
Is it, what, I don't know what the codes are for, you know, the going out of business store, but,
Right.
I expect that the signs.
Posters.
Yeah, that those posters are not considered signage under the city code because
Temporary of some sort.
They're
Yeah, yeah.
inside and they're
Yeah.
posters.
Sale or what have you.
All right, well, I'm okay with making a motion, if discussion is done. Where are we? Here we are. I move, that variance request for case VRB 23-50, for property located at 824 Southdale Mabry Highway, as depicted on the site plan presented at the public hearing, and as depicted in the renderings in our packets, to increase the number of signs per building frontage facing a public street from 3 to 8, the allowable sign square footage from 237 to 1,098 square feet, and allow signs on building frontage not facing a public street or an existing commercial structure, again, tied to the renderings provided in our packet, be approved, with the condition that they be, tied to the renderings in the packet. That variance, as conditioned, be granted based upon the applicant presenting competent and substantial evidence in the record and at this public hearing of an unnecessary hardship or practical difficulty when considering the 5 hardship criteria set forth in section 27-80 of the city code, specifically that the property sits on an unusually shaped lot in a high traffic area, that traffic in this area moves fairly quickly, and that additional signage, as depicted in the renderings, is necessary to help alleviate this concern.
Second.
motion by Mr. Feldman, second by Ms. Walrath. All those in favor say aye.
Aye.
Any opposed? 1. All right, your variance is granted 5-1.
Thank you very much.
Here's the,
All right, Mr. Eister.
yeah, no, wait, this is where it came from.
Stephen Eister, Natural Resources. This next variance is VRB 2353 at 105 East 26 LLC, or the owner is 105 East 26 LLC. The applicant is Stephen Lupin of Lupin Construction LLC. The property address is 109 East 26th Avenue. The zoning for this property is RM16. It went through a rezoning in 2021 to RS50 to RM18, the Euclidean zoning process. They are requesting to remove 1 grand tree for the construction of an 8-unit townhome development. The section in question is 27-284.2.5, permit for grand tree removal. The property is here listed. You can see it. It's 3 RS50 parcels that have been combined together to form one larger parcel. I have a better photo of that as well as we go through. So the tree in question is a live oak, 36-inch DBH. The canopy measurements are 45 by 62. The condition is C8, and the mitigation of this tree is 10 type 1 trees at 2.5-inch DBH. These are photos of the grand tree from the arborist report. You can see it has a lean due to competing trees on site. The tree does have the proper growth to support that arch in the structure. The other trees, so you can see the tree circled here is the 36-inch. This is the existing survey. There's a collection of large trees up front of the property. There's a large, like 50-inch ficus over here, and then other large oaks kind of scattered around the site. And that's kind of what led to that growth of that manner. This is the proposed plan. It shows the 8 townhome units. as you guys see in the staff report, there will be additional like corrections to this site plan beyond what's proposed for just the grand tree removal. The courtyards would have to shrink to allow for buffers. A DE1 would also be required because of the overlay requirements, because the doors do not face the front of the property, which is to the north of the drawing here, where the drive is and the guest parking. So this is the proposed. This is alternative plan 1. It shows 6 units. This option preserves the tree and the buffering the other trees around the site. This is option alternative site plan 2, which also preserves the grand tree in a courtyard type setting with the 4 townhome units going around, 2 going east to west, and then 2 in the rear going north and south with access off the alley. And then the other ones still have access off that drive down the center. So this is the consideration for the board. Natural Resources found the request inconsistent with tech standards and code. You guys can see my attached memo in your packet. The memo also breaks down the buffers that are required for the east property line and then the south and west, and then just the basic kind of requirements for a townhome development. And if you guys have any questions, I'm available after the applicants present.
Thank you. Is the applicant here? All right. If you could state your name, address, and confirm that you've been sworn.
Stephen Lupin, 4931 Southwest Shore Boulevard. I've been sworn in. Thank you. First of all, I think you mentioned something at the beginning about documents that weren't in the packet. I have a revised plan that actually shows the canopy. Okay, I want to make sure I was. All right, so the tree in question with our option number 1 is, as you can see, has a hard lean to the north, and the canopy covers about 50 to 60% of the buildable area. I've taken some different pictures of the tree. This is the tree looking to the north. You can see the lean. The distance from the ground to this part of the tree is approximately 24 feet. This is looking from the west. You can see how the canopy actually cantilevers over where the buildable area would be. Again, showing that it has a hard lean, and the distance from the ground to the main limb is approximately 24 feet. And one more looking to the east, essentially showing the same thing. So the reason I'm showing these pictures is to identify in our options 1 and 2. Let's see, sorry here. I'm going to put these side by side for you. This one here? There we go. All right. So the canopy of the tree actually extends to the north over the buildable area of this proposed structure. If we were to trim the canopy back, we would exceed the 25% that the ISA recommends for pruning of the tree. Plus, we would be pruning the roots, which would exceed, their recommendations for properly pruning a tree annually. We purchased the property in 2022, and it was already zoned RM18. We were required to present criteria for the board's consideration. The impact of the proposed building structure, building area on the impacted tree, as shown by a survey or drawing of the parcel of the property to scale, accurately depicting the location, crown spread area of the tree, including the minimum protective root zone around the tree. So our proposed development is an 8-unit, 3-story multifamily townhome community, which consists of 2 3-story buildings with 4 units each. The subject Grand Oak is in conflict with one of the proposed buildings and any vehicular traffic entering into the building. Our certified arborist assessed the on-site and adjacent trees in a report, and his findings was issued on May 22nd, or May of 2022. He stated that the minimum protective radius shall be 20 feet. The tree has an excessive curvature and an irregular crown spread. If the tree is not removed, the impact will be a loss of 3 units or 37.5% reduction to the project. Whether the proposed building structures can be reasonably reconfigured to preserve the grand tree for removal, including the recommendation by Natural Resources Coordinator or designee. Due to the irregular growth, the canopy spread, the radius of the protected area, we would lose 2 units, or 3 units, and the root pruning and of the crown and the pruning of the crown and the root pruning would be excessive and would send the tree into decline. So whether a reduction of the required setbacks for the primary building structure is sufficient to preserve the grand tree requested for removal, the reduction of the required setbacks would not be sufficient to preserve the grand tree due to its location in the center of the property. Due to the irregular growth of the tree, pruning the roots at the 20-foot protective area will only compromise its integrity and reduce the life of the subject tree. So whether alternative construction methods can be utilized to preserve the grand tree requested for the removal up to the critical root zone, again, due to the irregular shape and growth, alternative construction techniques would not prevent an adverse impact of the tree proposed for removal. So in closing, I believe we've met the 5 criteria. It is unique and singular. The tree is irregular, and it impacts nearly 50% of the buildable area for that particular lot. The proposed variance will not substantially interfere with any neighboring properties. The variance request is in harmony with the Tampa Comprehensive Plan and as it relates to redevelopment and multifamily development zoning of RM18. And granting the variance will result in substantial justice done for the owner and neighbor and the public. I'd like to point out that we purchased this property, it was already zoned RM18. So we did not create our own hardship. And that's all I have.
Right. Thank you. That completes your presentation. We'll open it up for anyone who would like to speak on this application.
Excellent, thank you.
Looks like there are a handful of people here. And to everyone who's about to speak, please remember to state your name, your address, and confirm that you've been sworn, and you have 3 minutes.
3 minutes. My name is Justin Rickey. I have been sworn in. My address is 109 East 26th Avenue, Tampa, Florida, 33603. I'm a current member of the Tampa Heights Land Use Committee. I'm a former board member of the Tampa Heights Civic Association. I'm going to read you my response that I've already emailed to all of you, or I believe I've emailed it to you. I feel it's important to express my opposition to this project. As a resident of this street for over 14 years now, I personally oppose this variance. Many of the reasons which our committee has alluded to in the preceding message, but most importantly, the continuing approval of projects that are not activating the street fronts in a way that promotes responsible development and growth. Street front activation is required for pedestrian activity, walkability, transit, as well as small business. Every time a project is approved of this nature, you diminish the full potential of future growth to occur, keeping us in a stagnant automobile-dependent environment. If Tampa wants to be the next big city, responsible development needs to occur in all of our neighborhoods, not just the CRAs. The hardship and practical difficulty for this project are self-created and do not justify a variance being granted to remove the grand tree in question.
Per the application, the property is zoned RM16 and allows a maximum of 8 units to be constructed. Failure to grant the variance will result in a reduced unit count, which will create a financial hardship to the developer and reduce tax revenues to the city of Tampa. I believe the removal of the tree is justified based on the location and structure and likelihood of compromising the integrity of tree roots if the tree roots are pruned at the 20-foot protective radius. First, a self-created financial hardship to the developer is not a qualifying hardship. At second reading on May 19th, 2022, City Council approved rezoning the 3 properties to RM18, not RM16 as erroneously stated on the application. Furthermore, maximizing density of the underlying zoning district and the comprehensive plan is not guaranteed. Applicable code requirements must be met to maximize density rights. Code does not restrict density to a particular product type. RM18 allows up to 8 dwelling units on this property, but the developer is not limited to a single-family attached units whose fee simple legal platting restricts the flexibility of the site layout. 8 dwelling units could fit on this property through condominium for sale or apartment for rent type products. A self-imposed choice to build only single-family attached units is not a qualifying hardship. How much time do I have?
You have 1 minute, 30 seconds left.
Second and most importantly, the project as designed does not meet City of Tampa Development Code 27-282.9C1, single-family attached design standards, which reads, the ground floor entrances, front doors of the dwelling unit shall face a street right-of-way, not including alleys, rather than the side or corner lot lines. Entrances may face interior courts, plazas, or similar design element with the approval of an alternative design by the zoning administrator. I'm done. I apologize. Thank you for your time.
My name is Carol Ann Bennett. I live at 4116 West Santiago Street, and I have been sworn. There are multiple problems with this site plan. This property is zoned for multifamily. They can build 8 apartments or condos. There is no zoning requirement to build townhomes. Just because they want to build 8 large townhomes does not mean they are entitled to it. The only entitlement they have is what they could pull permits for on the day they bought the land. They knew the Grand Tree limited them when they bought the property. By hoping for something that they are not entitled to, they were speculating on a land deal. That's on them. The citizens should not be made to pay the price of our critically shrinking tree canopy just because they speculated on a land deal or did not do their due diligence. They can build 8 condos and easily configure them around the tree. That would provide a lovely piece of green space under the shade of this grand live oak that benefits the whole neighborhood with heat reduction, oxygen, and flood mitigation. Even without the tree, their site plan is so flawed, it will probably be denied. In June, city staff gave them a long list of design requirements they had not met and told them to resubmit a new design that complies with city code. You have a copy. Even though they got a continuance, they still have not complied with that mandate. In addition, there are several other building code violations that City Council will not approve. Code requires front doors to face a street. Their front doors face the fence in the side yard. This requires a design exception. City Council isn't approving front doors facing a courtyard. They certainly won't approve this absurd design. City Council is also not approving these tunnel designs with a driveway down the middle. This project must be completely redesigned even if you grant the variance. If you approve this variance, it runs with the land. That means they could remove the tree and then be forced to design a plan that would have saved the tree, but it will be too late. That would be a tragedy that will negatively impact this neighborhood for decades. Tampa Heights Civic Association invited the builder to meet with them, but they did not show up. The neighborhood would love to see 8 apartments built on this site. This would provide flexibility to save the tree. They could pull permits tomorrow for a project like that because they wouldn't need variances or a design exception. The VRB is required to consider if the grand tree can be preserved through reconfiguration. This project must be reconfigured to comply with city code, so it is going to be reconfigured eventually. Preserving this grand live oak is a no-brainer. Please deny this variance. Thank you.
Thank you.
Good evening. I'm Lorraine Perino, president of the Tampa Tree Advocacy Group, and I have not been sworn in.
We'll go ahead and take care of that. And if there's anyone else here who hasn't been sworn, go ahead and stand now and let's all get sworn in.
Please raise your right hand. Do you swear to and affirm that you will tell the whole truth and nothing but the truth?
I do. How many of you on this board have read the city's 2021 tree canopy and urban forest analysis study released last April? The study states that so many grand trees have been removed from the city that they are now considered to be rare in Tampa. Quote, Tampa has a young forest and young trees, 3 inches or less. Old growth trees are rare. The study documents Tampa's tree canopy to have so deteriorated in the past 5 years that it is now, quote, at its lowest since monitoring began in 2006. Tampa's tree canopy has now decreased to 30%. The study goes on to state that, quote, the current 30% tree canopy coverage is a critical threshold for the health and well-being of its residents and of the environment. Tampa has experienced a continuous decline in tree canopy since 2011 and has lost 13% of our trees in the last 10 years, an area equivalent to 4 times the size of Davis Island, unquote. The science proves that Tampa cannot afford to waste even one more of its few remaining rare grand trees to satisfy greedy developers or irresponsible or clueless residents. Yet a reading of the private arborist report shows that developing this property would mean the destruction of no fewer than between 7 and 13 trees from this parcel, including one healthy and protected grand oak. It would be very easy to instead simply reconfigure the design of the proposed development as the city has proposed and preserve one of the last remaining rare grand oaks in Tampa. This past spring, the mayor proposed planting 30,000 trees in the city by the year 2023 in a valiant effort to regrow Tampa's deteriorating tree canopy. Preserving this rare grand live oak would be a significant step in that direction. Natural Resources has rated this grand tree removal inconsistent. Please vote to preserve this healthy grand live oak tree. Thank you.
Hi, my name is Pamela Jackson Haney, and I have been sworn in.
And your address.
I just wanted to point out that, again, that Natural Resources found this plan inconsistent. The one thing that did stand out to me in Mr. Eister's staff report was the 4th or 5th paragraph down saying, according to table 284.3.3, single-family attached development needs to meet the following requirements: 350 square feet of green space per townhouse and 1 tree per 1,500 square feet of parcel, excluding area of building footprints, publicly contributed platted wetlands. So that still, as far as I can tell, because I did look in the Acela too, still needed to be submitted. So also from what I can tell, one of the alternate plans would enable him to save the tree and also build his 8 units as he would like. And that's this one. Is this up? Yeah, that's this one. So the tree would be like it would be a courtyard, which would be really lovely, having that tree as the centerpiece, especially since the arborist said that it's in fair condition, C8. It does have a lean, but as Mr. Eister said, the tree is able to live on even with that lean. And the arborist said you could also be able to get as close as 15 feet with conditions. So maybe, the conditions would have to be, pier and lentil or whatever other kind of, permeable ground surface that needs to be used. And it may require a little bit of creativity and effort, but it can be done. So the other thing I wanted to point out was I happen to have the same tree in my yard, or a similar tree, that I've had several arborists look at too. I've lived here for 30 years. I don't know if you can see this or not, but this is my tree. It leans quite prominently, instead of to the left like this one, but to the right and over my driveway that I share with my neighbor. And so, because of that lien, we've had it looked at several times. And every arborist has said, it's fine. It doesn't need a lot more pruning because of the type of tree it is, a live oak. I have to keep it pruned 6 feet off of my roof, which is very easy for my homeowner's insurance company. And as you can see, it's very close to my house. It's not the required 15 feet, most likely, but it is, my house is on pier and lintel, so the front porch allows for that, and that can be done here too. So we're at a critical point with our tree canopy, has been mentioned many times. These grand trees are rare. It's time to keep every single one of them from this point forward. They will prove beneficial to the community and this housing structure. Thank you.
Can you state your address before you go?
Oh, sure.
I think you forgot that.
3014 West Harborview Avenue.
Thank you.
Sure. I'm sorry. Oh, okay, yeah. Sorry, I don't know what's mine and what's not. There's a bunch of stuff up here that I don't think is mine. You did? Okay.
May I retrieve my documents?
Yeah, yeah.
Apologies.
No worries.
Thank you.
Good evening, my name is Stephanie Pointer. I live at 7709 Landcare Lane, Tampa, Florida, 33616.
And you've been sworn?
I'm sorry, yes, I have been sworn. You know, hardship means that you can't live without something, that you need something. I think that this plan right here shows that this is a want, not a need. They want to make as much money as humanly possible off of this lot. Is that a need? Nobody made them buy this lot. They knew they were gonna have to do something about it. Very rarely do you see a neighborhood association support the number of units somebody wants. And yet, here we are. We have neighborhood associations who are saying, yes, you should build 8 units. Maybe the developer should consider these 8 units because they developed a plan that they don't have to take out this tree. This tree that was there before they bought the property, before they were born, before probably his grandparents were born. But yet, we get up every day and think, oh, this is a hardship. I need this. That's not the case here. This is a want, not a need. And we need to know the difference between the two. This tunnel plan that they had showed you, that's not gonna fly. It will not fly with city council. They will not approve it. The garage doors are not big enough. So you've got all kinds of issues with their proposed site plan, and they didn't bother to throw this up here and say, oh, well, we could do this, but we don't want to. See, there's a want. Hardships are needs. This shows that they don't need it. It shows that they want it. Thank you. Have a good evening.
All right. Anyone else that would like to speak on this application?
Sorry, anybody
Seeing
else?
no- All right, I'm going to open it up for questions from the board.
Do I get a rebuttal?
Yeah, well, we will probably have questions for you, so
Okay, sorry.
come on back up. I can go ahead and start.
I have a question.
Go ahead.
The site plan, the second site plan that Ms. Pointer just had up there, do you have a copy of that?
Yep.
Okay. Just have a question about it.
Sure.
Okay, so the tree is in the center of that courtyard, correct?
Correct.
Okay, and what is the distance between, so the tree arches, what's the distance between the tree and the ground where it arches?
It's approximately 24 feet.
Okay, so these buildings would fit under that tree?
No,
So this is not a viable,
it is not a viable plan.
okay, so I guess my question would be, why present a plan like this if it's not viable?
We were required.
Because the tree is not I see, okay, I see
We
what
were
you're saying.
required to submit 3 plans. And
Plans.
that was the only thing that fit on the site.
Okay, so this plan is not viable.
This plan is not viable.
Thank you.
Okay, so I have, based on that, I have a question for Mr. Eister. Let's talk a little bit about your finding of inconsistency. Was one of the reasons based on this site plan that's up on the overhead?
So, again, Stephen Eister with Natural Resources. My finding of inconsistent is, kind of like mentioned before, the max use of the property is 8 units. In my mind, like if we look at this plan with the canopy conflicts, say if you got rid of those 2 units up to the north, you now have 6 units with no canopy conflicts. So, or if I see other design factors like the front doors that aren't gonna face, so that's gonna have to be a redesign as well. So it's based off the tree, but then all the other factors that go into the site design that may have to change as well. So, what I looked at was, you could easily do 4. The other side is the trickier side because of the canopy conflicts. But the site could easily probably accommodate 6 units.
Okay, and we saw a site plan that did that, right?
There's this site plan that has 8 units with the canopy conflicts. You could do 6 without any conflicts. Or you have the one that splits it and you have a building on each side, but from the canopy conflict photo he showed, that would only probably get them 5 units. Okay. So probably a hybrid of this would get them the most without any conflicts.
Okay.
And if you're looking at that plan, Steve,
Yes.
it looks like they could actually maybe do 7, because only the one at the very top is a problem.
That's true. If you wanted to kind of work with that second back unit, you could get rid of that south or that east-west unit.
Yep.
And
at
have
the very
7,
top.
and then have access from the alley.
Okay, so they could do 7 with that plan as long as they worked with it.
Okay, so what I'm hearing is notwithstanding sort of the tree radius that's shown here, they couldn't actually build that one unit
Yeah,
to
so
the
it's,
north.
you got the twofold. You got the 20-foot protective radius, but then you have the canopy conflicts due to the arching shape. Say if we had more elevation, they could possibly slide in a unit, but at 24 feet high, if they were doing 3 units, which is probably about 36 foot high, like how high of,
The tree actually turns and is pretty consistent.
and then how high is the 3-unit townhome structure?
They're 35 feet.
35 feet. So then you have that 10-foot conflict, which would remove you would be left with a totem pole if you saved it and did a 3-foot or a 3-story building that close.
Can I answer that?
Hold on, I've got so I'd like to talk a little bit more about the tree, because just from the pictures, the tree looks like, I wouldn't want to walk under it much. It would be a little dangerous to me. So but I'm not a tree expert, so.
Oh, no, this
tell
is,
me a little bit about.
I have no problem answering the tree question. So when you have the competing canopies, the trees are gonna have a bit, what's called a phototropic lean, to grow towards where they can have the most access to the sun. So this site is pretty wooded, like stated, if you guys look at the survey, there's probably about 15 to 20 trees on this site. So as that tree grew and developed, it developed that lean as well. So if you guys go and look at it, you have a lot more structural wood on one side of the tree compared to the back side of the tree to support that lean. So kind of like it can hang over your driveway, it can have that lean, and you could sit under it. I'd be okay sitting under it, having lunch, or what have you. Or in like a courtyard setting like this.
So maybe more my question is, would you build a structure, like even a 1-story structure underneath it? It feels like that would be
I think if you could maintain the 20-foot protective radius and not have any major canopy conflicts, I think you could do a 1-story structure, because once you get to 2-story, you're hitting that 24 range where this canopy starts. So once you add
could you, I mean, I'm thinking more of the practicality of, we do get hurricanes, trees fall over neighborhoods all the time. Is that do you still have those pictures of those? When I looked at those trees, there was like nothing on one side. It's all hanging out to one. It looks like it blew over in a storm.
Right. So the way you gotta look at it is, this tree, say, has been growing, say, 40 years, just to give you an estimate. It's always grown that way. So the tree has developed to grow in that structure. So the root system has probably more roots on the back side of the tree to support that lean, probably less on the front side because it doesn't need them. And then it has the wood structure as well. So like when you cut, like say if you cut this tree, the growth rings on one side would be significantly smaller than the growth rings on this side, because the inside is putting on a lot more growth to support that leaning structure.
Okay, so maybe put differently, is this tree more likely to blow over in a storm than a tree that's standing up straight?
It's been here 50 years and it hasn't blown over yet. So the roots are doing their job.
So you mentioned, I'm sorry if I'm interrupting, do you want to go? You mentioned the root structure, and I just want to make sure I understand that, because it's not just the canopy that we need to look at, it's also the roots underneath. So tree is coming up and leaning, where's our, to the northwest, right?
Correct.
Northeast. And the root structure is going to be heaviest south of it?
Correct.
Okay, so when we've got this site plan here with the structures to the south of the tree, are those structures going to be impeding upon the root structure of that tree?
I think
if we were just working with those.
Yeah, if you're looking at the proposed plan that kind of shows that U shape, which is kind of the one we've been using, the proposed footer is actually going to be probably 25 to 30 feet away. The minimum protective radius the city requires to not impact the tree is 20 feet. That's that hash line you see around the trunk of the tree. So those footer impacts would be outside of the protective radius. And if we have additional concerns at the time of building, we'll ask for like an air spade report. So if structural roots are discovered, we'll ask for alternative construction methods to make sure we're not creating a more hazardous situation.
Would it be typical that a tree like this, because of the way it's leaning, it would grow farther than 20? I mean, I know our standard is 25 feet, but because it has to put so many roots out to counterbalance this, would you expect that there'd be more roots outside of 25 feet?
So again, after we can enforce the 20 feet, if we see any additional concerns, we can ask for additional information, like an air spade, where basically they take out like a high pressurized compressor, they trench out where the footer is and they assess it. If they find a 4-inch root, then we're like, okay, you guys need to do alternative construction methods to not further impact the tree and preserve those roots on that side. But it's subsurface, so at this point, I did not go out there with my shovel to figure that out, so it would be at time of construction. And they would also, if they preserve the tree, would get setback reductions. So, kind of mentioned in your comments, they could actually reduce, I think they have a 15-foot rear setback. So that could be reduced by 40% if they needed more space from the tree.
That's a great point. I was going to ask that question. I'm glad you brought that up. The current plans that are being presented, they do not include any setback reductions?
No, currently not. Okay. These are just the standard setbacks. They do have their buffers that they have to contend with as well.
Right.
But I think, let me double check my
But in order to preserve trees, we will allow a certain percentage of setback reduction to the setback. So the rear setback could be reduced.
Yeah, because the south and west property lines only require a 5-foot buffer. Okay. So they have 15 right now.
Right.
So they could probably pick up another, probably 6 feet.
I mean, if they come to the south, there's a 28-inch tree that would have to go.
Yeah, but
it's surrounded by trees, so if you're removing those buffers,
you're right.
They're going to be taking trees out any which way.
Correct.
Shift, do they still get those benefits for saving the grand, and they'll be allowed to take out everything else around
So the
it?
28-inch tree that's in question is in poor condition.
Okay.
I think it's noted in the arborist report. I don't even, if I remember correctly, I don't even think it's alive. So it wouldn't even count towards or against them.
That's an option.
In mitigation.
So just for clarification, if they start moving things around and it's a smaller tree, they still would be able to get the benefit by saving the grand tree?
Correct.
Okay.
Any other questions for Mr. Eister? All right, any other questions for the applicant or anyone? applicant, you have 5 minutes for rebuttal.
A couple things. First of all, there's, if we were to, can we turn this back on here? If we were to move this building south 6 foot, it really would not justify any additional room for this unit. Plus, there's utility lines that run along this. This is an alley, it's an easement. I don't see that being a benefit. The canopy is the problem. The canopy actually extends, it's 51 feet approximately from the trunk of the tree to the outreach of the canopy. And it's pretty consistent at 24 feet. If we were to trim the tree, if you look up under the tree, it's like a lollipop. There's very large branches, and then there's foliage at the end of the tree. By the time we trim the foliage to allow for construction of this unit, you'll have big empty limbs with no foliage. So that would not be beneficial to the life of the tree. Obviously, I know some people have a different opinion here, but we're not in the business to tear down trees. In fact, there was a 52-inch oak on another project of ours that the city approved to be removed, and we took extreme efforts to preserve it. And I have proof of that. So in this particular situation, we feel that this tree is, one, it obviously is impeding our right to develop reasonably, and two, any attempt to try to preserve the tree by trimming, root pruning, is only going to harm the tree. And I think that's all I have to say. And I would appreciate an approval. Thank you.
Thank you. I'm going to close the public hearing and open it up for discussion from the board.
It's tough.
It's
tough.
You guys?
I mean, the thing about the tree is the way the tree is growing. You could build something underneath, but the chances of insuring it, it's not going to happen. No insurance company is going to insure something under a tree like that. So I mean, the other proposals that they have, I mean, are irrelevant. They really are. There's nothing that's going to fall underneath that tree that is going to be insurable.
Well, and so when I look at the factors, one of the factors is really one of the more important factors is whether the applicant presented alternative site plans, which they did here, but one of the factors is also whether the site can be reasonably reconfigured. And so sort of the question that I'm weighing is whether building 4 or 5 or 6 units means that the property can be, whether building 4 or 5 or 6 units is a reasonable reconfiguration of this property.
Agreed. They may not get 8, they get 6.
Yeah, so that's kind of the way I've tried to look at these is, I do not believe and I do not interpret the rules that the city has given us to follow to mean that whatever a developer designs, they get to build unless they can reasonably reconfigure it to save the tree. I don't see that as what the city's intent was when it made these factors. The factors were designed to try and, as best we can, preserve trees and allow people to continue to use their property in a reasonable manner. And I do not believe that maximizing the amount of space that we can, the amount of units that we can put onto a property necessarily is that's what we get to do because that's the only reasonable way to go. I do see that there's ample use for this property. It may not be with the 8 36-foot townhomes that are planned here. Maybe it's 7, maybe it's 6, or maybe there's another way to do what they want to do. But I just don't see that the city intended us to say, well, you draw it, if it doesn't work with the tree, take the tree down. That's just not how I read that. that factor.
And they can do 8 units in an apartment configuration so that you don't have an enclosed garage for each unit for 2 cars and so on and so forth. So you can get 8 units in there, it may just not be these 8 units.
Yeah, and I don't wanna be in the business of redesigning the properties for them. I'm just saying, I can look at this, and under the existing proposals, they can get a reasonable 6 to 7 units out of this. I get it, that tree's gonna lean across there, and you're not gonna build anything underneath there, that's not a reasonable approach. But there's still ample ways to use this property, and still, even under the way that they were factoring, I think there's a reasonable reconfiguration here. So under that scenario, and with that interpretation, I don't support the removal. I do not, by the way, I do not read any ill intent into this developer. I think this developer is doing what they need to do. I just don't think that they can get everything they want here.
You ready for me?
I agree.
My biggest, and the hardest thing for me on this one is the tree just doesn't look.
Well, remember, we're not under a hardship criteria, and that's something that the city probably needs to do a better job of in our applications, because it does very clearly say the grand tree removal factors, and then our applications still have that hardship form in there, so it kind of tricks people into using the hardship format. But we're not under a hardship here. This is a tree removal factors under 27-284.
What is the grade of the tree? Do we have that?
C8.
Yeah.
And remind me, what is that?
C8 or C9.
What's the expected life?
Steve
on
can
that one?
probably answer that.
It depends. Does staff answering questions count? I don't want to get more testimony. It's in the application.
All right, with that, does anyone have a motion?
I can do it. All right, I move that the variance request for case VRB -23-53 for property located at 109 East 26th Avenue, for the removal of a grand tree be denied due to the failure of petitioner to meet the burden of proof that the tree would be rendered hazardous by proposed construction that cannot be reasonably reconfigured when considering the factors set forth in 27-284.2.5F, the city code for grand tree removal, specifically that there's been no utilization of setback reductions, that the reasonable reconfiguration as demonstrated by some of the alternative plans suggests that it is a viable, there are viable options here, and that it is simply not necessary to maximize all of the units on this property in the fashion that the developer has proposed.
Second.
Motion by Mr. Feldman, second by Ms. Walrath. All those in favor of denial, say aye.
Aye.
All those opposed? None. Right. Your variance request is denied. You can appeal it to city council. All right, variance request for case VRB 23-54.
Hello, Stephen Eister with Natural Resources. The next case on the agenda is VRB 23-54. The property owner, it was Neo Homes when the application began. The property then has changed hands. Neo Homes is the agent though for the VRB still. The applicant is Jason Gardenia. The address is 1019 West Ohio. It's single-family residence, RS 60. The variance is to remove a grand tree to construct a new single-family home. The code criteria for review for grand tree removal is 27-284.2.5. permit for grand tree removal. This is the site. The site was originally a 120 by 130 lot. The developer bought it. The existing home was demoed. The arborist report was obtained on 03/16/23. Following the arborist report, a certification letter was filed to split the large lot into the two 60 by 130 lots you guys see now. So they own the lot highlighted in red, or they sold that lot highlighted in red, and then they still own the lot to the left. The tree in question is a live oak, 50-inch canopy measurement of 56 by 94. The tree was rated B6. The mitigation value is 23 type 1 trees at 2.5 inch DBH. This is the tree in question. As you see, it's a live oak towards the front of the property along the property line. The survey will show that. So this was kind of like what I just broke down for you. The box highlighted in blue is the lot in question today. The tree circled in yellow is the grand tree in question. Currently, the lot is vacant. It is empty. There's nothing there. This is proposed plan 1 that shows the house constructed, the tree there in the front, again highlighted in green. There's the square footages. This is all in your packet as well. This is alternative site plan 1. You can see the house has been shifted over to the side setback. This is very similar to the same as proposed. At the time of the memo and before the hearing last month, the day before, a plan was submitted for that hearing. It was not usable for this hearing. It has surpassed the timeline, so I will put that up on the projector so you guys can see that. So this is an additional alternative plan that they submitted. So as you can see, what they did was they used the setback reductions in the rear yard and in the side yard to shift the tree back into the corner. The house design was not flipped, so there's still some driveway conflicts. The tree is now outside the footprint of the house with this design, but it's still within the protective radius. We're going to swap back over to the PC. So these were two, just kind of like to show the buildable area that we would allow with the setback reductions. This was in their memo that I gave to them. Just a couple of quick drawings for them to explore some other options to preserve the tree and still build a house of similar size. And then here's the criteria for grand tree removal that you guys were asking about, not the hardship criteria, but the reasonable reconfiguration criteria. And then if you guys have any questions or concerns, please let me know. One thing I do want to mention, their arborist report is the one that provided that B6 rating. I then went out and inspected the tree and agreed with their arborist and what he submitted.
Thank you. It's the applicant here. All right. And just a reminder to state your name, state your address, and confirm that you've been sworn in.
Yep, I'm Jason Jardina, 6706 North River Boulevard, and yes, I've been sworn in. Thank you for your time. I'm here representing our clients that are for the purposes of building their primary residence on this property, their forever home. We took all their requirements and requests, the way they live their day-to-day lives, into the designing of the home. We consulted with our arborist on the reconfiguring of the home, and everything we came up with would be temperamental to the tree. If we took out so much of the canopy, the tree would suffer and decline and cause a hazardous for the new home and then the neighboring home next door. We did take into consideration, we uploaded the site plan, I guess, a little late about reducing the setbacks, six to the side, 12 to the rear. But that, family also has plans on putting a swimming pool. Having a 12-foot rear setback would prevent them from having a swimming pool built into the project. Even with, pulling the setback, okay, let's say to 15, would reduce 535 square feet from the floor plan due to canopy conflicts. So this is the floor plan reduced back to a 15-foot setback, which would allow for somewhat of a swimming pool in the rear of the house. With the canopies, without trimming any of the canopy, you're reducing the first floor level by almost 200 square feet, 195 square feet. And a lot of the canopy going in, or section of the canopy going into the garage, basically, forcing you into a single-car garage versus a two-car garage to gain entrance to the home. The second story of the home, you would lose approximately 350 square feet of the home due to not pruning the tree. So to not lose that amount of square feet, you have to prune the canopy quite a bit, which would result in a decline in the tree, the health of the tree. The shaded out limbs would have to be removed to be able to salvage, the square footage of the home, the flow of the home required by the homeowners. The foundation of the home would be approximately 5 feet from the base of the tree. I've built a lot of homes in Tampa, and I've never been allowed to build a home 5 feet from a grand tree. Even if we could, the cost of the foundation would put an extreme hardship on the clients financially to be able to afford to build a structure like that. There was another comment I noticed on the natural resource report about rear entrance to the property, having a garage in the rear. That is not possible either. There's about an 18-inch grade difference from the alleyway to the property. There's like kind of a natural storm drain system kind of through the alley that would prevent any sort of access in and out of the rear of the property. And that's all I have. Any questions?
All right. Is there anyone in the audience that would like to speak on this application? All right, just a reminder to state your name, address, and confirm that you've been sworn in.
Judy Richter, 1015 West Ohio Avenue, and I have been sworn in. I am the adjacent homeowner to this tree. My property boundary is 15 feet from this grand oak, and I've known this tree for the last 26 years and have had no problems with it at all. And having read the staff reports and the visits that your arborists and foresters have made, they have suggested alternative location of the garage. So the tree is, from all reports, is a healthy tree. It's a big tree. So it's a question of where to put the garage and alternatives. And since it's a vacant lot, there's possibilities. Whether it's to the west to the property boundary or to the back. They could also keep the garage in the back and put in a driveway from West Ohio Avenue to the back, My adjacent neighbors did just that. So it's a viable option to retain that tree. The tree itself, it's a huge canopy, and it provides shade all day long to the front of the yard, which means the homeowner would have minimal landscape irrigation demands for that. My property next door, most of the time it's in shade because I have a lot of trees. And I have a grand live oak right in front, which is within 50 feet of this tree. And they provide structural support to each other, because I know in 2004 we had 4 hurricanes in 6 weeks. So that was scary enough. But Francis, I think, was the one that came closest to our neighborhood. So we experienced wind gusts of from 30 to 50 miles an hour. These trees hardly moved. They protected our properties in just this portion of the street. So we had minor branches and twigs that fell, but these trees were sturdy and they stayed. And residential water use, by and large, a good percentage of residential use is for landscape irrigation, not so much inside the house. So the demand that the city has to provide water to all of us, especially this year, when we're in a drought and still in a drought, and the excessive heat, that goes fast. The demand for water is important. And to reduce the city's demand to buy water a second time this year from Tampa Bay Water could be reduced if we keep our grand oaks. So my support is for the tree. I would love a new neighbor, but not at the expense of this tree. Thank you.
Good evening. My name's Ari Fitzgerald. I live at 710 West Indiana Avenue in Riverside Heights, and I have been sworn. So I already sent y'all a detailed letter with facts and figures, and I'm not going to restate them here. But variances require that both the seeker have a hardship not of its own making, and that granting the variance won't create a hardship for others, and this request fails on both counts. There is no real hardship, and this is not a close call. To the extent that the applicant claims a hardship, the hardship is of its own making. If they want a bigger house on the property, they shouldn't have subdivided the lot. The tree is on or near the property line, and I know this because I walk my dog by there every day. It was there when the developer bought the property, and they didn't have to buy the property if it didn't fit their vision for their home. The lot is vacant. It's a clean slate. They don't have to work around existing architecture. Plans can be modified to accommodate the tree, or they should sell the home to someone who will love the property as it is with the tree. Building and zoning codes necessarily limit what one can do to property. There's no reason the applicant can't put a different house on the property, and they need to be required to do so. The other reason that the applicant should be denied the variance is the hardship it will create for the adjacent property owners. The tree provides significant shade to the next door neighbor's property, as you just heard. I know for a fact that removing the tree is going to cause their house to heat up like an oven, because during that 4 hurricane onslaught, we actually did lose a tree due to the storm on the west side of our property, and our house heated up like an oven. Think of the impact that removing that tree will have on their power bill, their landscaping, the life of their paint, and their home's curb appeal even. Removing this tree to indulge a developer will cost the neighbors a lot of money. How is this even fair? The impact on the environment will be enormous. Again, I sent you some facts and figures on that and links to information, so I hope you read it. The tree is a large one. The applicant doesn't meet the criteria for a variance. Any alleged hardship is of its own creation and will create a hardship for the neighbors directly and indirectly on the rest of us. In terms of our lifespan, this tree is truly irreplaceable. Make them build a different home to accommodate the tree and deny the variance, please. Thank you.
Evening.
can see the scale. My name is Donna Date Smith, 2403 West Chicago Avenue, South Tampa, and I was sworn in. I request that you deny the request to remove this grand tree with an excellent rating of a B6. You asked that before. Bs are great. Bs are the granddaddy of grades. If you have read the 2/21 Tampa Tree Report, you know that Tampa's canopy has declined to a record low of 30%. The importance of grand trees, most of which are on private land, needs to be acknowledged by this board and taken into serious consideration by developers when they create their site plan. Each grand live oak is an essential natural resource for the city of Tampa. Grand tree removal should be avoided unless there truly is hardship or danger involved. It has become a common practice for developers to split lots, create cookie-cutter designs that use up the entire lot without consideration of its natural resources. Then they turn the interference of these resources into a hardship as a way to justify their design. There was no effort by this builder to reconfigure their design around the grand tree. They have not acted with good faith effort to create a reasonable configuration that would preserve this tree. Removing this tree will cause a hardship to the city ecologically as well as financially. The mitigation fees collected for removal of a tree would be $7,000. According to Whit Reamer, Sustainability's latest budget proposal indicates that the cost of planting and maintaining a type 1 tree, which this is, for 5 years is $1,300. This tree is like 100 years old. Mitigation for a 50-inch grand tree would require planting 23 type 1 trees, which will cost the city taxpayers about $30,000. Fees have not kept up with the inflation, so it's no surprise that builders ignore the value of grand trees and gladly pay the bargain rate mitigation fees that do not accurately represent the expense and irreplaceable loss that is created. Grand trees must now compete for space as density of housing has become a critical issue in Tampa Bay. But the continued decline of canopy due to legal removals is something this board can influence in a positive way. I implore you to start by saving this tree today and to continue to act with heartfelt concern regarding any grand tree removals that are brought before you. Thank you.
My name is Caroline Bennett. I live at 4116 West Santiago Street. I have been sworn. The unique criteria the VRB must consider for grand tree removals requires reconfigurations that will preserve the tree. The actual definition of reconfigured is, quote, the arrangement of parts or elements in a different form, figure, or combination. The applicant did not meet this requirement. The code requires them to use special reduced setbacks, 6 feet on the side and 12 feet in the rear, to shift the house more than is normally allowed. They didn't meet that requirement until after the deadline, and even then, they did not make a good faith effort. In none of their reconfigurations did they even flip the driveway to the other side, and it's the driveway that's in conflict with the tree. You can see from Stephen Eister's example here, he shows the driveway on the other side, and this large area right here that can be used to build a very large home. The code requires the VRB to consider, quote, the recommendation of natural resources, which is what this is. It plainly shows that as the code demands, you can save the tree and still build a reasonable home. The only conflict with the grand tree is the garage. There is an alley behind this property. We visited the site and saw that people living behind this property are using the alley for rear access. So this is their property, and this house right here, they're using the rear access from the alley. The house doesn't even need to be shifted if they put either an attached or detached garage in the back. This is a 50-inch, exceptionally healthy, extraordinary B6 live oak that will live for centuries. It will provide benefits to your grandchildren who are not even born yet. It will outlive your great-grandchildren. According to the 2021 tree report, the Tampa's forest should be an even mixture of trees of different sizes. But our forest, Tampa's forest, is out of balance and is classified as a young population, which is bad. Live oaks are only 3% of Tampa's trees, but they provide 19% of our leaf area. Our mature live oaks sequester more carbon than any other tree and save more money with avoided runoff than any other tree. Mature live oaks are the workhorses. They're the most valuable infrastructure this city has. This tree is 24 karat gold. It is the Cadillac of trees, and it should be treated that way. The code does not allow removal of a grand tree for a swimming pool. If the applicant couldn't build what they wanted on this parcel, then they shouldn't have bought it. It's that simple. They speculated on a land deal. Please deny this variance.
Good evening. My name's Chris Zeller. I live at 802 West Kentucky Avenue, Tampa, Florida 33603. I've not been sworn in.
If there's anyone else here this evening that might speak that needs to be sworn in, we'll go ahead and take care of you right now as well.
Please raise your right hand. Do you swear to and affirm that you will tell the whole truth and nothing but the truth?
I do. Thank you. I had emailed my comments maybe a month ago to the VRB. Dear VRB panel members, the purpose of this letter is to request that you vote no on the grand tree removal located at 1019 West Ohio Avenue, Tampa, Florida. I've lived in Tampa for the past 38 years, the last 25 years being a resident of Riverside Heights, and I'm saddened to see how Tampa's tree canopy is quickly declining to the point where many Tampa neighborhoods now have few trees. The removal of the healthy grand live oak is not in the best interest of our community and is yet another example of the lack of preservation of these valuable trees that we continue to decimate. I think we can all agree that it is prudent and the responsibility of the property owner to investigate to determine if their lot is suited for proper improvements and to what degree. Why would they not inquire about this tree prior to splitting the lot? To claim hardship in this instance is extreme due to a tree that has been in existence for years. The owners may build, perhaps not to the degree that they wish. The public, you and I, should not be penalized for the negligent investigating and neglectful due diligence. Grand trees provide Tampa neighborhoods with essential shade, cooler air, and a lower heat index. These are benefits that the healthy tree canopies across the Tampa Bay area provide. We as residents look to our local officials to reliably protect our interests for the betterment of our communities. These decisions are extremely important and have a lifelong impact in many instances. I'm not against sensible development by any means, but there must be a balance between protecting our nature and our future expansion. Please protect our magnificent trees and the canopies they provide across the Bay Area. They cannot be replaced overnight and take generations to grow. Your proper vote can ensure such and keep Tampa Bay beautiful. I ask that you spare this tree from destruction and truly contemplate the wishes of the greater Riverside Heights neighborhood residents, as well as the larger Tampa Bay community, and vote no to this grand tree removal request. In saving this tree and others, you'll allow it to provide a home for God's nature. You'll allow it to give humans joy and life-giving benefits. And best of all, you'll allow it to live. What a great achievement. Thank you very much for your time.
Good evening again. I'm Lorraine Perino, president of the Tampa Tree Advocacy Group, 604 Ontario Avenue, Tampa. The tree at 1019 West Ohio is one of the rare grand trees left in the city as described in the city's 2021 Tree Canopy and Urban Forest Analysis Report. It is a massive, healthy, 50-inch live oak with a magnificent canopy. At 100-plus years of age, it is just one of a few such grand trees left in Tampa. It must be preserved, not only for its own sake, but also for the health and well-being of Tampa's residents and for future generations as well. Development, they say, is good for business and by extension good for the city. But development must be carried out responsibly, not in a manner that is destructive to the health of its residents and the environment. The city must stop predatory builders and clueless or irresponsible residents from putting their own selfish financial interests, profits, and desires ahead of the well-being of city neighborhoods, residents, and the greater Tampa community by giving them permission to rob the greater community of our grand trees and of the benefits they provide to all of us and to our native wildlife as well. Countries all over the world are planting millions of trees in an effort to combat global climate change. The federal government is granting huge sums of money to cities to plant more trees. Tampa itself just received a $1 million federal grant to plant more trees. When it comes to tree preservation, Tampa cannot afford to persist in its misguided belief that it can continue to allow the destruction of its old-growth trees and then plant its way out of a seriously deteriorating tree canopy by planting young trees, which will take 60 years to reach full maturity and begin to provide the benefits that Tampa's old-growth grand trees are providing to us right now in the present day, like this 100-year-old beauty. City government must become part of the solution in preserving Tampa's few remaining rare grand trees and not be part of the problem that allows these trees to be systematically stolen from Tampa's neighborhoods and residents and native wildlife. Neighborhood residents are demanding that their grand trees be preserved, not destroyed. The well-being of all Tampa residents demands that the destruction of our grand trees stop now. Removing a 100-year-old healthy grand oak to install a swimming pool is an unacceptable reason to remove a 100-year-old healthy grand tree. It is an unacceptable waste of one of Tampa's most precious endangered natural resources. A vote to preserve one of Tampa's last remaining massive grand oak trees will help restore confidence by residents in their local government. Please vote to preserve this old-growth live oak tree that started its life and managed to survive to this grand old age long before anybody in this room was alive. Thank you.
Hi, my name is Pamela Jackson-Haney. I've been sworn in. My address is 3014 West Harborview Avenue, and I'm also a member of the Tampa Tree Advocacy Group. A lot of us have been talking tonight about the latest tree report, and hopefully you all have a copy. If not, please ask Mr. Eister if he can get you a spiral-bound hard copy. If not, it's online. It's really it's a work of art, just reading the whole thing through. It says our canopy is at a critical point and that we should save and cherish our precious grand trees that we have left. Live oaks make up only 3% of Tampa's canopy, the lowest percentage of any tree other than the buttonbush and the swamp tupelo. And I don't know if any of you know what a buttonbush or a swamp tupelo looks like, but you do know what a big live oak looks like because those are always the trees you notice when you drive around Tampa because they're just so gorgeous. But they're going away fast because of unthoughtful development, and that's one of the biggest killers, especially on these types of lots where they're building these really big homes. As you can see, the tree in question has been rated a B6. It's 50 inches. The mitigation is 23 2.5-inch trees. I saw the pictures, but I had to drive by to see its stunning beauty, and it didn't disappoint. The massive trunk is something to behold. The arborist who examined this tree and the city forester found the removal of this grand live oak inconsistent. The fact of the matter is the lot is still very usable even with this tree because it's located to the far right of the lot. The applicant for this tree removal states the following hardship. Due to the tree's location and size, the lot is unusable for a single-family home. This lot is zoned for single-family homes. Not true, it's not unusable. To me, the biggest issue here is the developer isn't even trying with their alternative plans, something we see far too often, which says a lot. They want to remove this priceless Grand Life oak for a garage, and they have no wiggle room. The following requirements of the Tampa Code criteria of section 28284 B, C, and D show why this request should be denied. With our forest examiner's suggested alternative building footprints, the tree can be saved by either flipping the house by putting the garage in the back and accessing it via the alley, or by changing the setbacks. And there's more good news. This house has a flat roof that will be lower than the tree canopy and thus conducive to saving it. With a little effort and possibly alternative construction methods, this tree can be saved. The developer can go back to the drawing board, and I'm sure with his capable team of people and the new owners, they can come up with some good options to save this priceless grand oak. And one more thing I did realize, and a couple of other people have said this, my grandson's 20 months old, and he will not live to see one of the mitigation trees, if ever planted, grow to the size of this majestic, healthy 50-inch Grand Life oak if it's taken down, and that's very sad. Please save it. Thanks.
Good evening, Board. Fred Henry, 1209 West Braddock Street, Tampa. And I'm just going to kind of partner up with what Stephen said over there and staff. I think the last site plan that was represented, I guess missed the deadline, was thinking in the right direction. I've had the pleasure of working with staff on a number of alternative foundations, and you know, it's easy to do if you had the engineering to do it, and you know, the wherewithal. But I'm here to offer any assistance I can to the builder if they want to go in that direction. I think the same house would work on this plan. I don't know, there we go. If with some creativity, I've been in front of this board to ask for setback relief in the past, you know, to save a tree and unfortunately remove one. But I think in this case, and excuse my simple, you know, cutout here, it's the same house. Flipping it over was definitely the answer. And, you know, going near the back of the property, encroaching the 20-foot setback, maybe some side setback relief with an alternative foundation in that ring. If you have to, you can put a paver driveway in. The house with a flat roof does make sense for that tree. And I think really, you know, for the vernacular of the neighborhood and that house placed in there, keeping that tree could make sense. The owners could be creative with their pool desires. You would use the side yard more as a rear yard in this example. But in my humble opinion, it could be done with this model with a little bit of creativity. I know the existing house that was there, it was demoed per the attached survey and record. You know, it took up quite a bit of that yard. There's a 50-inch live oak. This is the arborist report. And so it's about 30 feet, you know, from center, distance of 15 feet away. There was a structure here, so that would help with the root raking and the area around that to be pruned. So I think there's viability. Again, I've had the pleasure of working with staff before on things like this. We actually have a house we did with a 57-inch grand right next to it, and it's fine. So I'm here to offer any help I can to the builder. I think it's a great opportunity to save the tree and build around it if prudent, you know, if you be prudent about it. So, yeah. Anyway, that's all I have, and thank you very much.
Thank you. And just for the record, could you confirm that you were sworn in?
Yeah, oh yes, I have been sworn in. Yes, thank you for reminding me.
Good evening, Stephanie Pointer, 7709 Lancare Lane, and yes, I was sworn in. This is a neat little chart, and so we went back there and did a little math. If we convert this number here into gallons, 537 million gallons of water were saved, were soaked up by these live oaks in 2021. That's a lot of freaking water. And then we wonder why we have much more flooding than we have now. One of the neighbors down the street, she had to leave because she couldn't stay here all night. She said that there are 10 grand trees gone from this little stretch of street. That's a little bit excessive. 23 saplings will not mitigate this live oak. I think that Mr. Henry showed us that you can work on this and make a viable site plan. And again, I'm going to remind everybody, want versus need. No one needs
exactly this house on this lot. If it doesn't work for you, find a new lot. Sorry. Or build something different. Not everybody gets what they need. Wait, not what they want. And sometimes, you know, what is it, the Rolling Stones said? So my buddy Carol Ann, I'm not the tree hugger here. I'm just here for the impacts. Notice that our tree canopy in 2021 saved us $306 million throughout all these different ways, the carbon emissions. And every time, every single solitary one of these trees counts. In South Tampa, where we lost like 35% of our trees, guess what? Those didn't come off of the apartments. They went one house at a time, legally or illegally, but they went one house at a time. Just like children who are stolen, one at a time. We have to start today saying no. Thank you.
All right. I am going to open it up for questions from the board for the applicant and staff.
No one. So, Mr. Eister. I want to go back to those green boxes that you had. You
Okay.
have those handy?
Yeah, we can pull those back up. Is the PowerPoint still open, Laura?
All right, so first question. This is a 50-inch grand oak.
Correct.
Might be the biggest tree in perhaps the best condition that I
Yeah.
can recall ever seeing before the board.
I would agree. B6 is a very, so this is actually a great example. So you guys can see the difference between a B6 and a C8 when you look at the structures of these two trees.
Yeah.
Because I know rating comes up a lot. So a B6 is one step away from A, which is like what you see in a textbook.
Yeah.
So B is just right below that.
So my question to you is this. On those gold circles on that drawing,
Correct.
is that simply the 25-foot protective radius, or is that a depiction of the spread of the canopy and roots?
So what I did was, based off their arborist report they submitted the canopy measurements. The lowest limb is 26 feet from the ground. Their elevations they submitted with the flat roof are at 25 feet, which I know is close. I know that's gonna come up, but with a flat roof structure, if you're gonna kind of work with a canopy, I think that's your best chance. But with the reductions in setbacks and different options like that, you could really push it out. And I think the canopy goes from 26 up to 28, and then it goes up from there. So it's 26 at the closest, then 28, and then what the measurement is beyond that.
Give me some measurements as to, so I understand that now as to the canopy and the roots. Give me some measurements as to those green boxes that you've got drawn.
So
approximately what kind of square footage can you get in there?
So I sent these in the original staff report. I do not have CAD, so these are all hand-drawn with tracing paper to the best of my ability.
So do you have a rough measurement as to?
I would say these are comparable to what's proposed. I think it's proposed it's 4,000 square feet, and then they have a 10-foot lanai off the back, which in a reasonable reconfiguration, a lanai is a lanai, you know, it's outdoor living space, it's not square footage of the home. So that gives them another 10 feet of wiggle room if they were gonna scratch the lanai and do something else outdoors. So I figured that was an easy spot to pick up square footage as well, because I'm just trying to give them some creative guidance, especially when their arborist report states that they got before they split the lot. On page 1, at the very bottom of the second paragraph, removal of this tree will require a variance. So I'm trying to give them all the tools to meet all the requirements we have so they can present the best case possible. No reconfiguration of the house occurred with their 3 plans. They shifted it, and then they shifted it back with the reductions. The house was never flipped. As you can see with both these proposals, it shows the driveway on the other side. Because the major conflict is the two-car garage and driveway. It's actually not the main structure of the home, but the garage and driveway. So I kind of tried to give them some ideas so then they could go back and hopefully redesign by the time they got here in front of us.
Okay.
Or get them out of, keep the tree and get them out of the process altogether.
Since you brought up the issue of the lot split, was it, Neil Holmes was the one that split the lot?
Correct.
Okay. Question for legal. What consideration, if any, can we give toward the lot split, whether that be towards self-created self-created, I know this is not a hardship criteria issue, but what consideration, if any, can this board give towards the split of that lot as it impacts the tree?
Well, I mean, I think you can consider the fact that the applicant or the purchaser is the one that split the lot.
Okay.
You know, I hear a lot of, when you say we don't consider the hardship criteria, to my mind, the reasonable reconfiguration is what you kind of use to establish whether or not there is a hardship or not. So if the site can be reasonably reconfigured, then perhaps there isn't a hardship. So you don't just scrap all the.
Yeah, I know. It's
So,
just
okay.
when we look at the hardship criteria, it's different than when we
Well,
look
you
at the
still have
tree. I understand you're
Yeah.
saying there still has to be, you still have to evaluate a hardship.
Correct.
But
Correct.
they're different rules, they're different considerations. But, so you're saying we have the ability to consider that, to take in, okay, all right, good to know, thank you.
I'll go on one last one for you, Mr. Ister.
Yes.
There was a gentleman up here talking about the previous home that was demolished and how it was approximately, foundationally, was 15 feet from the trunk of this tree.
Yeah.
Do you guys
So-
take that into account for, possibly letting the structure be slightly closer since
Correct.
the tree root structures probably aren't in that area?
Yeah, so if you look at the second diagram, with the kind of the more oblong shaped house to accommodate the drive up front, that would kind of can take that in, because that's like a 5-foot encroachment into the, by best estimate, with a pencil and a ruler. So the goal is to be like, hey, you guys can do 5 feet, because that's how close the original house was, so we'll give you credit for that. Because a lot of times with older houses, you got the deeper footers than what's really, I feel like, is used now. So there's not a lot of root conflict there, because there's nothing under that footer that those trees want.
Okay, so
So-
that gives us even more space.
Correct, they could use the existing footers, and I would have taken that into consideration as well.
Very good, thank you.
Thank you. Any other questions from the board? All right, applicant, you have 5 minutes for rebuttal.
So I just want to touch base on the splitting of the lot. Originally, this was platted as 2 lots. And we just, we didn't reconfigure the lots. We restored them back to the original plat that was originally 2 lots from the beginning. And I wanted to point out one more thing. This lot is actually zoned for a building footprint of 3,910 square feet. We're proposing a building footprint of 1,836 square feet. So I mean, we are designing way below what's allowed for a lot this size. So we're not overbuilding on a lot in our eyes. And the limbs being hanging over the home 1 foot above the roof line, that would definitely become uninsurable home. The first thing an insurance company is gonna say, cut the limbs back. Somebody will come out and start cutting limbs back, and then, as the arborist in the report says, you start taking away the canopy, it's gonna decline in health and become a hazardous tree. And hopefully you guys can take all that in consideration and approve us. Thank you for your time.
We can close the public hearing and open it up for discussion or a motion from the board.
Yeah, similar concerns to what we saw on the last application, where, again, we have the ability to use the lot. This is not, you know, sometimes these trees, as glorious as they are, become their own worst enemies because it makes the lot completely unusable, right? The spread of the tree, the spread of the limbs, the location of the tree. And I was worried, based upon the fact that this was an unsplit lot, split lot that became two lots, that maybe that would be the death of this tree. But it does look like there's ample ways to reasonably reconfigure this home and still preserve what is honestly, in the 10 years that I've been involved, roughly from an alternate to on this board, this has got to be the biggest and perhaps the best rated tree that I've seen come before this board. And I just have a lot of trouble approving the removal of it. So I'm not in support of removing this tree as it currently stands.
No, I'm with you there. And the fact that these other solutions, these green boxes, as you mentioned, those layouts were not really explored, even after Steve sent them that information. That concerns me, that there are other options out there that need to be looked at.
Yeah, I feel like this is a highly buildable lot, even the way it sits. And in fact, I think the lot is way more valuable with the tree there. It's an incredibly beautiful tree, and I think you should try and celebrate it and adapt to it. It's not you can't not put a house on this lot. You can absolutely put a big, beautiful house on this lot and take that into consideration. So.
You can make a motion. No. You do it.
Do you want me to do it?
Sure.
Okay. I move that variance request for case VRB 23-54 for property located at 1019 West Ohio Avenue for the removal of a grand tree be denied due to the failure of the petitioner to meet the burden of proof that the tree would be rendered hazardous by the proposed construction that cannot be reasonably reconfigured when considering the factors set forth in section 27-284.2-5.2.5 F of the city code for grand tree removal, specifically that the home can be reasonably reconfigured to preserve the grand tree. The home can utilize setback reductions. There's ample space on this lot for buildable area. In fact, ample space to build almost the exact house that is proposed, just with some reasonable modifications and reconsideration. I would also note that the existing house had footers that were fairly close to this tree, and utilizing those existing footers can provide even more space for a builder who is trying to put a house on this lot, as well as the consideration that it was this applicant that split the lot and restricted the space as well. Although that's a secondary consideration at best.
Second.
Motion by Mr. Feldman, second by Ms. Plorap. All those in favor of denial, say aye.
Aye.
Those opposed? None. Right. Your application's been denied.
Can I say one? I was going to say, before everybody starts leaving, I want to thank, I know this meeting's been going on for almost 4 hours, and I want to tell the neighbors and everybody who came and spent this whole evening with us that we appreciate you taking the time to do that.
They're not leaving yet.
Yep.
Can we take a
We
5
are,
though?
we are going to take a 5-minute break, yes.
I just need a drink of water.
Okay, I understand that we have a request for a reorganization of the agenda. So I'd like to ask someone on the board to make a motion to move VRB 23-58 to the next item on the agenda, and then we will hear item 23-55 as the last item.
It just simply stated. Okay, I'll make a motion to move VRB 23-58 to item 8, replacing VRB 23-55, which will move to item 9.
Okay. Motion by Mr. Fry, second by
Second.
Mr. Mercury. All right. Come on up. Okay, so this is VRB 23-58.
Yep.
VRB 2358, the applicant and owner is Mulvair Francis. The property address is 2429 South Ramona Circle. The zoning is RS60. The variance request is to reduce the front yard setback from 25 feet to 15 feet for the construction of a carport per section 27156C. Here's the aerial of the property in red. Here's the front of the house. Natural resources is consistent, transportation is consistent, right-of-way is consistent. Here's the site plan showing the carport and showing it 15 feet from the property line. Here's a rendition. Here's some elevations. Here's the standards for the VRB for the 5 criteria. The applicant has answered the question. They can expand if you would like. And that is the end of the presentation.
All right, applicant, state your name, address, and confirm that you've been sworn.
Mulvair Francis, 2429 South Ramona Circle, Tampa, Florida, 23612, and I've been sworn.
Chaz Willott, that's my mom, 5411 South 87th Street, Tampa, Florida, 33619. I've been sworn in.
Okay, you have 10 minutes.
My mom's elderly. She's having surgery on her knee in the next couple days. Days. The carport would be a cover for our driveway, well, her driveway, so that weather doesn't impede on her. She's having knee surgery, and she's fallen a few times due to this, getting out the car, trying to run and get into the house because there's no covering, and we feel like this would alleviate it. I think that's it.
Okay, so go ahead.
I'm sorry. I'd just like to add, this is the second surgery this year on my knee, and it's a really bad fall risk. I've been falling a lot, and my son is really worried about me, and I would appreciate it if you guys could approve.
Okay.
Thank you.
And so some of the things we typically like to hear and with these sorts of applications is what is sort of unique to the property. So when we approve a variance, it has to be tied to the property, but not necessarily like something that's personal or something, you know, that affects just the owner of the property. We like to see it tied to the property itself. So some things that we typically look for is, you know, is there something unique about this property? Is, you know, where the house is sited, you can't, you know, install a carport somewhere else, for example. You know, another example of the kinds of things we like to see is, are there carports in the neighborhood like this?
Yeah.
Is there any other information you can add that maybe would help us?
Not at the moment. We just tried to go through the proper channels, and we were told this is what we had to do. Everyone, I want to say everyone, but there are a few other houses in the neighborhood that do have carports. The fence was added a few.
It was there.
It was there?
It was there.
Okay, well, the fence was there, and it has a motorized gate, so that makes it a little bit easier for her to come in. But the way that the driveway is set up, once she steps out, if it's raining, there's what are they called, the eaves, whatever the overhang is off of the house, it like dumps water right where she backs in, so it causes a really slick area right there. So when we called the contractor, they said the way to alleviate that would be the carport, so we went through the channels and came here.
And I also checked with quite a few of my neighbors, and they have no problems with it at all.
Great. All right, so with that, is there anything else you'd like to add?
Nope.
Okay.
That's
Is there
it.
anyone in the audience that would like to speak about this application? Seeing none, I'm going to open it up for questions from the board.
Got a quick one. How long have you lived in the house? Or how you owned it?
24 years?
1996, something like that, right?
Yeah.
And I see that there's not any room on the side you could get past with a driveway or anything to put a carport elsewhere.
Any other questions?
Sure, do you have any idea when the home was built?
58.
58. And I see it looks like there's a large commercial property to your rear. What is that?
There's a school at the back,
It's a
but there's like a huge fence, and I think there's like a pond back there, so.
It's not a pond, it's like, I can't explain it, it's like a ditch that's dug out. It fills up when it rains a lot, but I don't wanna say it's necessarily a pond, it's probably a makeshift one, I guess, at this point.
It's like a drainage swale.
I'm sorry?
It's like a drainage swale.
Yeah, but that's exactly what I would categorize it as. But it's fenced off. It's for I want to say like a charter school, a K-12 charter school.
Yeah. And they have a really high fence back
It's a
there.
stone fence.
Okay, very good, thank you.
All right. Everyone else good? All right, you have 5 minutes for rebuttal if you need it.
Thank you.
Thank you.
All right. I'm going to close the public hearing, open it up for a motion.
I move that the variance request for case VRB 23-58 for property located at 2429 South Ramona Circle be granted as depicted on the site plan presented at the public hearing for a reduction in the front yard setback from 25 feet to 15 feet for the construction of a carport. Based upon the applicant presenting competent and substantial evidence in the record and at this public hearing of an unnecessary hardship or practical difficulty when considering the 5 hardship criteria set forth in 27-80 of the city code, specifically that it's an older home built in the mid-50s. They did not have any sort of car cover or carport structure living in the state of Florida with as much rain. That could become an issue. I don't believe there's any public safety issues. There's a existing fence around the property, so no one could really even access this area. Additionally, the property itself is a little different, considering it backs up to a large school property.
Second.
All right. Motion by Mr. Murphy, second by Ms. Walrath. All those in favor, say aye.
Aye.
Any opposed? Nope.
Thank you, guys.
Thank you.
Thanks for swapping this too.
Yeah.
All right.
Last
guys
one of
just-
the night.
Last one. So the last case on the agenda tonight is VRB 2355. The owner is Justin and Christine Houston. The applicant is Skill Architecture. The property address is 2802 West Bay Avenue. The zoning is residential single family, RS50. The variance request is to remove 2 grand trees for an addition to an existing, to add a 2-car garage. This section of code and reference is 27-284.2.5, permit for grand tree removal. This is a photo of the lot. It's a RS50 lot. The measurements of the lot, just for your guys' reference, are 70 by 200. The 2 trees in question there's 2 grand trees connected at the base. Each trunk has been separated into these 2 separate measurements. Grand tree 1 is 47 inches with a 30 by 25 canopy in a condition of C8. Due to the small canopy, because of these 2 trees growing together, you'll see the low mitigation is 3 for the first one. And then tree 2 is 42 inch with a 36 by 32 canopy. Also a C8, the mitigation is 4 trees at 2.5. So to figure out the canopy of both, you would add those together to get the overall. These are photos of the tree here. So this is the trunk. You can see the dual trunk here on both sides, and then this is the overall canopy. The tree arches over the driveway towards the front yard. As you can see, they already have a modified driveway within the protective radius of the tree. It's utilizing turf block at this time. The proposed addition would go to the corner of this house, and then it would have the 2-car garage and then an addition to the rear of the 2-car garage. This is the existing survey. You guys can see the existing driveway that's being utilized currently. This is the proposed site plan. You guys can see the 2-car garage that extends out to the front of the porch into the protective radius of the trees, and then goes back with like almost like an ensuite kind of setup. This is alternate site plan 1. It removes the garage and allows them to do the addition outside of the protective radius of the tree. This is alternative site plan 2, which has both the 2-car garage and the addition, but it pushes the structure back. I would have pushed it back a little more, so then you would have access from the garage to the back porch. If you see, it kind of conflicts. The garage right now lines up with the kitchen, but that is also out of the protective radius of the trees, and like they could use a modified driveway. Again, they could use turf block or to preserve the trees in that manner. Natural Resources found this site plan inconsistent. If you get, my memo is attached along with the tree consultation that was performed by Sarah Arnold. She is no longer with us, or I had to asked her to come today. But option 2 and option 3 both preserve the grand trees. I also gave the additional options of exploring like a porte cochere, because it doesn't use the full footer, it uses pillars, so they could kind of bridge over it. The one downside to that is I think their request referenced like crime, and they wanted a secure area to put the cars, and the porte cochere doesn't provide that. But I just wanted to kind of give them some options to look into to kind of alleviate that inconsistency. And that is it.
Thank you. The applicant can go ahead and come up, and just a reminder, name, address, and confirm that you've been sworn.
Thank you. My name is Justin Houston. I live at 2802 West Bay Avenue. Yes, I've been sworn. Thank you all for coming this evening and allowing me to speak to you. I understand there are varying perspectives about the removal of these two protected oak trees, and I understand both sides of the argument. These trees are valued and beautiful. Ballast Point, our neighborhood, is the same. Very beautiful, and we love it here. I've thought about the people directly impacted, the 4 neighbors that would be impacted. Last names are Hoker, Pastori, Riley, Bracco, and they have approved the trees being removed. They have done this without being prompted and in a non-persuasive manner. Not one of them is here tonight opposing this tree removal. To the contrary, they've all sought me out over the last few days and given me their support. Why? Why? Because this is about safety and security. This is not about me or my family devaluing the natural beauty we have on our property. For clarity, the purpose for the addition is safety and security. I had an ankle replacement on December 14th, 2021, and now my second neck surgery to repair a herniated disc. No, this is not an early Halloween costume. Having our vehicles in a garage would help alleviate massive stress for me physically, as I am no longer proficient in navigating slippery surfaces because of my ankle. I cannot run as it risks destroying my artificial ankle. I say this as it relates to security. In terms of security, we, our neighborhood, continue to deal with folks coming through our neighborhood and attempting to break into vehicles. This actually occurred as recently as last night on Elberon, a street only 50 feet from our residence. Additionally, my wife goes to the gym to stay physically and mentally healthy at 4 a.m. every morning. Right now, I wake up with her to see her to the car and away. Did I also mention that we have snakes, raccoons, which you heard earlier, and opossums on property a lot of the time? We do not kill them or try to dispose of them because we appreciate the nature we have. Having this garage, by way of removing the trees, allows us to not have to worry about that and a lot of this. I realize that we have a big lot, and someone could say, just build in this direction or just build that direction, but then it becomes their dream and not ours. It's also our money that we are spending, not theirs. The beauty of our property is that we also have 6 other beautiful oak trees, and we would love to keep these, but city requirement, we have 6 oak trees in addition to the 2 we were looking to remove. We love to keep the ones that we would like to remove, but the city requirements are you can't build within 20 feet of the grand oaks. No matter where we build on our property, no matter what somebody comes up here and tells you, trees will have to come down. And we are trying to utilize our property effectively and in a way to best promote the growth of our beautiful neighborhood. You saw from this display, connecting the garage to the front of the house by that front porch looks significantly better than connecting it to the kitchen, just for aesthetics purposes. Again, no matter where we build, trees will have to come down, and we're trying to utilize our property effectively and in a way to best promote the growth of our beautiful neighborhood. We also have 3 children, ages 11, 9, and 6, and we want them to be able to play in a backyard, their backyard, the reason we bought this house. Our tree removal will continue to allow us to joyfully spend time with each other in our incredible backyard on our amazing property. This is a need for safety, and in my opinion, everybody has the right to feel safe on their property and in their home. Thank you.
Thank you. All right, is there anyone who would like to speak for or against this application? All right, just a reminder, name, address, and confirm that you've been sworn.
Hi, my name is Carol Ann Bennett, 4116 West Santiago Street. I'm a founding member of TTAG, and I have been sworn. Honestly, this variance is a little bit of a mystery to me. The lot is 200 feet deep. They're sitting on 1/3 of an acre. This is an unusually large lot. The third option shows that they can have everything they want, all the safety, all of a closed garage that is attached, and you can go right into the house. You can have the additional living space, and you'd still have tons of backyard left over. I didn't hear anything from the forester about option 3 requiring the loss of other trees. Option 3 is basically perfect. It just shifts it farther to the back and solves all the problems. The city code says that you must consider if it can be reconfigured to preserve the tree, and the answer is a resounding yes. Just use option 3, problem solved. The city code also says that alternative construction methods can be utilized to preserve the tree. And the answer to that is also yes. It's right there in the staff report. Use a pervious material for the expanded part of the driveway. They already did it on the front circular drive. And I'm just gonna say that this is not something that, if this gets appealed to city council, that they're going to approve, because it's just so obvious that they can work around this. It's 1/3 of an acre. I'm surprised they weren't advised just to go with option 3 from the very beginning and saving themselves all this time. Natural Resources finds it inconsistent. The VRB criteria tells you that it's inconsistent. Deny the variance, please, based on the staff report and the city code, and support the mayor's goals of preserving our tree canopy by denying this variance. Thank you.
Good evening, Donna Date Smith, 2403 West Chicago Avenue, and I have been sworn. I'm here to request you decline giving a variance for the removal of 2 healthy grand live oaks at 2802 West Bay Avenue. The alternative site plans provided by the arborist demonstrate that it is possible to create, the owner's desire addition by simply placing it further back on the property, away from the trees, and making a permeable driveway, just extending the driveway they have. Please help save our dwindling Tampa grand oak canopy by voting against this variance. Thank you.
I'm her picture assistant, just so everyone knows.
Good evening again. I'm Lorraine Perino, president of the Tampa Tree Advocacy Group, 604 Ontario Avenue, Tampa. It takes a tree
Can you
approximately
please swear?
50 years to become a grand tree, not yet. A child born today who has a tree planted in their honor will reach middle age before the tree begins to provide shade, oxygen, pollution storage, heat index lowering, and all the other benefits that trees provide for that child and for the larger local community, if that tree survives to that age. Newly planted trees have a multitude of obstacles to overcome before they can achieve grand tree status. Natural environmental challenges, constantly changing weather, freezes, high winds, droughts, flooding, possible saltwater intrusion, damage or destruction by rodents and other animals who eat their leaves and chew at their barks, destructive insects, beetles, deadly fungi, viruses, and bacteria, as well as deadly diseases spread by infected pruning equipment. Trees must also survive harsh winter storms or deadly summer hurricanes. To attain the age of 50, 75, or 100, a tree must survive improper pruning by commercial tree cutting companies and homeowners whose ignorance can destroy a healthy tree. Today, a tree must survive commercial builders and developers wishing to remove trees for their own financial gain. And finally, trees today need to be able to survive homeowners who wish to remove them for their own self-interest, not realizing or caring about the effect removing a grand tree or protected tree will have on the entire neighborhood and larger community. A picture is worth 1,000 words. Here's a picture of the live oak tree across the street from my house in 1978, when that tree was probably 20 or 30 years old. That tree there. Next picture. Here's the same tree in 1982 when my now 45-year-old daughter was 4 years old and hunting Easter eggs with her cousin in our backyard. And here's the same tree today, having achieved the status of grand tree. This tree had to survive all those obstacles in order to become a living being of beauty, majesty, and benefit to the entire community. Now here's the Bay Street, the 2 grand oaks at 2802 Bay Avenue, which the homeowners wishes to remove. These 2 trees. The width of their trunk shows that these 2 trees are 50 or 60 years old. Knowing how many obstacles these two grand trees have had to overcome to arrive at this age, and knowing how long it takes trees to achieve grand tree status, and now knowing how rare grand trees have become in the city, and knowing that also that the homeowner has 200 feet of additional depth in his backyard in which to build his add-on garage, don't these trees deserve to be preserved? Don't we owe it to these two beautiful grand live oak trees and to future generations to preserve their lives and allow them to become as beautiful as the tree across the street from me is? I believe that we do owe these beautiful trees at least that much consideration for all the benefits that they provide to that particular Tampa neighborhood, but also to the larger Tampa community as well. Please vote to preserve these two grand live oak trees. Thank you.
Hi, Pamela Jackson Haney. I have been sworn, 3014 West Harborview Avenue. This is a rhetorical question, but I've heard this over and over again this evening about people wanting to take the trees out because of the pruning required. Once they're pruned and the work is done around, the trees, it's going to damage the trees to such an extent that they're going to fall over. And I thought that, the city has requirements in place before you prune a tree, and I've seen it actually on other streets where new houses are built, where, the arborist will say, you can build this house, and this is the way you prune this tree to keep it safe and healthy and also build the house you want to. So it all, can be done. But anyway, that's just an aside to this particular case. Again, reiterating what Carol Ann said, this lot is huge. It's 70 by 200 feet deep. That is a really abnormally large yard. And I know this might sound strange, but I know some people who used to live in that house. I remember the backyard, and it is a beautiful backyard. Plenty of space. It is lovely. And I remember thinking, wow, this is a really big backyard. And so this gentleman and his family can have it all. They can have the trees in the front, they can have their garage, they can have their addition, and stay safe like they would like to in their home, which, we all want to stay safe in our home. That is true, what he said. It's absolutely true. So according to the code here and the standards and the criteria that you all have to go by, it obviously can be reasonably reconfigured by one of the plans that he showed. I think it's number 3. And then number 4, using alternative construction methods can be utilized to save the grand trees also, to save the critical root zone. So please vote to save these 2 grand trees. Thank you.
Good evening, Stephanie Pointer, 7709 Landcare Lane, Tampa, Florida, 33616. I have been sworn. 3 neighborhood leaders wrote you and said, this is a bad idea. I was one of them. Actually, that makes me 2 associations, but the Gandy Civic Association voted to not support this. The Ballast Point Neighborhood Association leader wrote a letter against this. Honestly, I get notifications for everything south of Gandy. And very rarely do I show up for tree stuff, and very rarely do I look at tree stuff and go, this is egregious. This isn't 1 tree, this is 2 trees. And yeah, this guy it's his lot. You know what? I have 3/4 an acre in South Tampa. And I have lots of grand trees on my lot. As a matter of fact, the city wanted to take 3 of my almost grand trees. They're 35 inches. Okay, and you know what I told the city? Hell no. They can't take out my trees because those trees were there before I bought it. And I'm sorry, safety? Okay, safety is you put your 24 by 24 2-car garage in the backyard, and then your wife drives around the front. You're safe the entire time. So is your wife. I got all kinds of metal in my leg. I broke 4 bones in my foot a couple of years ago. You know what? I never had a garage, and I got back and forth just fine. Carol Ann pushed me around in a wheelchair. I had a walker. I did all of those things. I'm sorry, not sorry. It's not that serious. put the garage in the back. We're talking about a 24-foot by 24-foot structure on a 200 by 70-foot lot. Think about it. It makes no sense to take out trees just because, oh, I don't like these trees here. I guarantee you, if I wanted to take out my trees, my neighbors would be here too. You know why? Because just like I said earlier, one tree at a time. And this guy isn't just going for one, he's going for two. It's rude and disrespectful to our entire city. Thank you.
Right. I'm going to open it up for questions from the board. You'll have a rebuttal in just a second.
Yeah, no, I've got one first, Mr. Eister, as usual. So these are C8s. The one that was at like the 90-degree angle, also a C8.
Yeah, so
Okay.
Stephen Eister with Natural Resources. The trees are connected like kind of like this.
Okay.
So it's kind of like you take one, you kind of got to take them both kind of deal. 'Cause-
Okay, so there was no way to separate one over the other.
No, because they're connected at the base.
I'm
and, like-
looking at one of these photos and I see the one leaning towards the house. It looks like a pretty decent sized limb is almost sitting on the roof.
Can we go, let's see. Let's go back to the,
It would be page 21 if you have the same setup as I do.
Yeah, I think so.
all right. So if you actually look, and you can kind of see this on the site plan as well, the indent in the driveway on the survey. So it's kind of hard for me to see because I got captions over it, but there is an indent and it actually falls in front of the house. And that's where the tree goes. So I know the picture probably is not the best with the
Okay.
depth perception of it, but
Okay.
it possibly hangs over the front porch more than it does the main structure of the home.
That's a
Then-
great transition to my next question.
Yeah.
Much like the other home that was there that was removed and we were able to move within the 20-foot buffer or 25-foot buffer for the larger tree, since this tree only seems to really exist in front of the house,
Correct.
is there a modification that's available outside of a variance to scoot the garage and everything, say almost parallel with the house and not
So-
the front porch? Instead, this, I'm seeing an extreme here, right? So we moved the garage all the way back the full 20 feet. It's sitting almost on the back of the house.
Correct.
Is there an opportunity for it to be moved forward almost to the to the front porch since the trees only come forwards?
Yeah, so if you look at the house, and let's go back to this survey. This one's probably the best. If you see that hash line in the front yard, that's their 20-foot setback from the property line. So that space from that property line back is all buildable space. It would impact their front porch area, but they do have that large space in the front. If they
Oh, I'm
wanted-
talking about the actual tree radius, the protection zone of the trees. Since the trees seem to be heavily proportioned to the front of the home, and since they're not touching the home and they're so far forward that they're actually not even touching the roof line of the existing home,
Correct, okay.
is there an availability of reducing that 20-foot ring around the tree to where you could bring the garage forwards? I mean, obviously, we're trying to figure out something here that
Yeah.
works for everyone, where we get to keep the trees and the homeowner gets what they're looking for at the
So
same time.
we, by code, we can allow 5 foot of encroachment, which is, you can reduce the radius down to 15 feet, and then you can use alternative construction methods. So you could do an elevated footer there, or
So he has to do that to get in the 5 feet, or he has to do that if he
Correct.
wants to go further than the 5 feet?
into the 5 feet. So if you took, say.
So there's no specific case for a tree that seems to only exist on, this side and not so much that side?
Yeah, so like if you look at option 3, which is kind of the topic of really the main discussion, that shows the garage could be there and the addition. The garage in this configuration then lines up with the kitchen. So currently on all 3 plans, there's no entrance from the garage into the house, which I'm thinking is just a architectural miss. So that's what prompted my discussion to bump it back to the back porch. Because you're not gonna take out your countertop to put a door in to access the garage. So
Yeah, but then to
you
get to
either
the
have to
other,
bump
to
it
get
up.
to the other part of the house, you gotta go outside and around into the other part of the house.
Right, or you bump it up into the 5-foot encroachment and then access it through this portion of the house, the front portion, which I don't know what this front portion is. It just looks like a great, or like a living room maybe. Or I don't know if they plan on having access to the home through the garage. That part I don't.
I think
I'm
the
assuming.
original plan shows access.
There's a toilet.
So this is the original plan.
The one where it
I
takes
guess
it
maybe
out.
it's a pocket door right
You
here?
see the stairs going down into it?
Cause the
There's like a laundry room
addition,
with the stairs going into it.
Oh,
cause
yeah, but
the,
that's coming all the way around.
so it looks like the only way out of the garage is into the addition. So if that's your only access point anyways, shifting it back
Yeah.
would not really affect the flow of it. Cause you're just driving a little bit farther down your driveway. This is the way I looked at it. Cause I don't see another set of stairs anywhere to exit the garage into the main structure.
Okay, so, correct me if I'm wrong, you're talking about alternate foundations, but you really can't do that because it's a garage, it's gonna be a slab on the ground, you can't, there's no
Right,
foundation.
so if there's no footers, that's even easier to work
Well, you
with.
still gotta build a wall on the side of the garage,
Right.
I mean, that's not, because you got a 12-inch deep footer or whatever, I mean, it's gonna be on top. I don't know that encroaching into the root zone is a really, like, there's not an alternate construction method to build a garage
And-
on elevated
and-
piers.
And the way I look at it, option 3, and you have a 200-foot lot, your garage doesn't need to be necessarily attached to your house either, but I wanted to kind of stay with their concept. I didn't want to drastically be like, do a detached garage, you have 3-foot setbacks, and leave them at that. Cause I know they want access from the home to the garage.
This may be a question for the homeowner, but you might already know. We weren't provided a profile. Is this garage have living space above the garage? Is it a 2-story garage or is it a single-story garage?
Single-story garage.
Okay, and the addition behind is also single-story?
Single-story, yes, sir, because that's where our master bedroom will be, so I don't have to, and I get it, it's a first world issue, but so I get to stay off stairs and things like that.
Okay.
So one of the things I see about option 3, there's no access to the addition from the main house. They're having to go outside the porch. And then, in order to get down into the garage, which I assume looks like it's 3 steps down into the garage, you can't go straight out the side of the kitchen down into the garage. You would be able to park a car on that side.
Yeah, so the only, like you were saying, and that was one of my concerns too, because none of the plans show access from the addition.
I think the first one does. It's very close.
So this is the first one here, and I guess
Come out
maybe
the
if
back
that's
of
a,
the kitchen?
if that's like a little pocket door, maybe
No,
in
it's
the
just
front.
it's a breezeway out of the kitchen. I mean,
So,
it looks like it's just a connected hallway. Right on the back side of the kitchen, right by the little.
okay.
We can ask the homeowner too.
Yeah, he could answer that more.
So it would be a single-story garage into mudroom with a hallway that accesses the kitchen, that also sort of has an L that bends, or just goes back to the master bedroom. I don't know if L is the right description, but the hallway.
Mr. Houston, so I guess the question is, how do you get from your bedroom, this is in addition to the bedroom, right?
Yes, sir.
How would you get from your bedroom to the main home?
There'd be a hallway.
Oh, okay.
Yeah, so the hallway would come
It's right
sort of
here.
adjacent to that brick patio,
Yep,
and then you take a right into the
Gotcha.
existing kitchen.
okay, I see it now, thank you.
Yes, sir.
Could put the garage on top of the.
The ramp.
I'm joking, sorry.
So I have a question for Mr. Houston.
Okay if I just stand up, because
Sure.
he's sitting and standing, not
That's
all
all right. Usually, when we hear about crime, it's typically because we're addressing things like a request for a higher front yard fence than is typically permitted, or barbed wire, or things like that. But in any instance where we talk about crime as a connection to the hardship, we would usually look for some crime statistics. Did you bring anything with you today?
I don't have any statistics, no, sir.
Okay, all right, thank you.
Okay, Mr. Houston, I have one other question for you. So, you've heard us talk a lot about sort of these alternative site plans. can you give us sort of your thoughts about this, the alternative site plans? I believe that you're the one who sort of put these together and submitted them.
Yes, I did. So the original plan, or you asked me about the alternative. So the alternative plans, everybody's talking about option 3 right now. Option 3 is much more difficult than it sounds, particularly from a economic standpoint, because if all of a sudden our garage is into our kitchen, now we got to figure out a way to rebuild a kitchen, right? And that's, in my opinion, $100,000, and that's not where we want our money to be spent. It also pushes back physically, which everybody in the building has pointed out, into our yard, the structures that we want. The garage pushes to the north, the master bedroom pushes to the north. We have beautiful oak trees in our backyard. There's 6 of them back there, beautiful. And there is no, I'm telling you, there's no way, right, to do this without something coming down. And so what we tried to do to combat having this garage offset from the front of our house another 20 or 30 feet and looking, I guess for lack of a better word, goofy and sort of doesn't give you that southern style home feel that we're looking for and that I feel our neighborhood exudes. It just looks sort of like piecemeal, like, oh, okay, great. These guys came in, spent some money, threw some bricks down and some drywall, and here they go. It doesn't look good. I don't think it has the Ballast Point taste that people are looking for. So when you talk about these alternative options, yes, they're there. We can cut down other trees, right? And the point here that people don't want these trees to be cut down, I get that and I appreciate that. These trees are beautiful. That limb that you referenced, that hangs over my children's bedroom, right? I didn't even come here and talk to you about that, right? But that does scare me, whether people like it or not. And I've been very respectful. People keep talking when I'm talking and chitter-chattering while I'm talking, right? I haven't done that to anybody. I'm being very honest with you and the whole committee, and I've been honest the whole time. The best way to do this is the way I've pointed out. Yes, there are other options. Yes, it's going to cost additional money, and it's not going to look clean, right? I understand the preservation of trees. I do, right? And I've also heard that tree preservation has, or tree removal has been approved tonight as well. And so that's why I'm here, just in hopes that people see our perspectives. I certainly understand others. But again, this is, to me, it's a safety and security thing. I mean, may I put my phone under here to show you something? And look, can you see that?
Oh.
All right, I don't care what anybody in here says, and I know we all have things that are going on. That is my ankle stitched up after they took the biological one out and put a new one in. And the life on these things is only about 15 years. 10 years ago, they were 2 years, right? I'm not here because I don't like oak trees. I'm here because I want to be able to play with my kids and run around with them. And I know others are here to preserve oak trees, which I do respect. You take out my backyard, then there's no point, like, then where, right? And it's easy to say, well, go out front and go here and go there. But this is the dream home we bought, right? No one else bought this. We bought this. I'm an educator. I spent every penny that I've ever made to buy this house, okay? Like, this means something to us. This isn't like, let's cut down a tree and prove people wrong, okay? Like, this matters to us, and that's why we're here.
So real quick, you want to build, you're building an ensuite so you have a first floor bedroom.
Yes, sir.
Okay. Guys, the biggest thing I see about this, I see option 3 everybody looked at, and it looks immediately like a great idea until you start looking about, he's gonna, that cupola in the back of his house has got to go away. You got to build, take out half or a third of the porch. You got to build some new way to get from the kitchen back around there. It totally messes up the backyard openness of the kitchen out to the yard by trying to get to this new ensuite.
Well, it defeats the purpose of having the master ensuite. It's no
Right.
longer an ensuite.
Yeah,
You have
it's
to go
an
outside to
ensuite.
get
It
to
doesn't-
it.
You can't build that ensuite without.
It's a pool suite.
Well, that's why you were suggesting, that's why you were
I
talking
was trying
about
to
that
say,
option.
if you were able to slide this thing
of
forward enough,
shifting
and it's hard to say from here.
halfway.
Obviously, I don't have a scale or anything.
Look, in
and,
a perfect world, if I could save those trees and put this thing up, I would do it.
If you slid the stairs, like basically the garage came up to 5 feet, those 3 steps of stairs would be right there at the entrance of kitchen. You would have to lose this laundry, or not laundry, but possibly like a linen closet right here next to the master bath.
We'd have to lose the
That would
mud
basically, your
room.
mud room would become the hallway into the master.
Right.
So you'd come through, you could either take a right, go into the garage, take a left in the master, but
Well, that's kinda what he
that's
has.
making a very huge assumption that
Right.
that's only 5 feet. I mean, if it's 7 feet, well, then the guy's SOL.
Right.
I'm looking at the staircase, just as a, I look at plans for a living, look at the staircase, I don't see any way you put that staircase in where that pass-through comes out of the kitchen. That staircase right now is already 5 feet back, it's back by the back corner of the porch. You're outside to get onto that stair to get down to the garage. And don't forget, it's an elevated
Well, I'm
house.
saying if you shifted the whole thing, the additional 5 feet into the 20-foot zone, the trees which we're allowed to do.
But but the problem with that is, that's only if you can do an alternate foundation method, but you're talking about pillars or piers that go around the roof.
It's a single,
It's a garage.
it's a single story structure. If it was 2 stories, I'd agree with you, it would need a larger foundation.
Well, I understand, but it's a garage, it's a flat slab, you can't put the flat slab on top of your roots. Even if you encroach upon that, yes, there's other alternate, like, you could put turf block and that kind of stuff.
I
You have
thought,
to do
maybe
that
I
in the garage.
misunderstood, I thought Mr. Eister said that you could do that.
Well, he said that you can do alternate piers, but I think there was a confusion point, correct me if I'm wrong, that you can't do piers in the bottom of a garage.
No.
No. You can't, but even amongst us, we've come up with all kinds of other options. And I don't know that those have been,
Well, and I think that we're also getting a little bit away from the questions for the applicant.
exactly,
But that's not an option.
exactly,
He's
that's
got-
not,
that's not the
that's
purpose of
not
this
what we're
addition.
here for, that's true.
Are there any other questions for the applicant or for
Yeah,
staff?
I do. So you keep mentioning these other trees that would come out if you shifted things backwards. Which trees?
I mean, I apologize, I don't have a picture of my backyard, and I'm not being rude.
Well, I mean,
or
I'm looking at a
disrespectful.
site plan, so, I mean, are there,
A 27 and a 12. If you have to keep the 20 feet or 10 feet off of those, you'd be able to just.
well, I don't know. I mean, there's no way to tell
This is
that.
7 feet.
Well, the 27 inch is definitely encroached upon. Can you pull up the site plan? The alternate, look at option 3, and look right behind the master bed. Right on the property line is a 27 inch tree.
Yeah, right on the, which side of the
Like by
property?
the end table? right
No,
off the side
west,
there.
east
So
side
if
of the property.
So by using the same kind of a 20-foot setback circle around that,
But he wouldn't have to come before us to ask to remove that one.
What,
It's not
Yeah,
grayed
but-
up, right?
27 inch?
I thought it was like 32 that became a grand.
that's true, but what I think his point was, you're
Yeah,
gonna lose a tree.
you're gonna take down some
You're
big
still gonna
trees.
lose a tree,
Agreed.
so yeah, you can take out the smaller
Yeah, but
trees.
it's not
But we're talking about, we're talking about size.
More questions for him, we can discuss amongst ourselves.
Yeah.
I thought that's what we were doing, I just thought. we were-
No.
Oh, we counted it now. We're still in the question period.
Yeah, I think I'm done. Okay.
All right, so you have 5 minutes for a rebuttal.
Just on the things I think we've talked about everything that I wanted to talk about, and I just want to reiterate, this is not about us not valuing nature. That is not the case. This is about us trying to do what's best for us as a family and uphold what we consider a very beautiful neighborhood by building an addition that looks appropriate for the neighborhood. No matter where you build on our property, hand on the Bible, on my mother's soul, God rest it, trees will have to come down. And then the farther we build back, the more it becomes, it's really not even an addition, it's just, I don't even know what it is, right? And, I've spoken my piece. Thank you all for all of your perspectives as well. And that's it. Thank you.
Thanks. All right, so now I'm gonna open it up for discussion from the board.
I think this is slightly different than the other ones that we looked at.
I agree
This
with
is not a new building.
No.
This is something that is being added onto an existing structure.
It's not,
So
and-
when we were, I mean, you can be more liberal with the redesign aspect of something on a completely empty lot.
Yeah, but our charge is still reasonable reconfiguration, right? Our charge is still to determine whether what is being proposed can be reasonably reconfigured to preserve the trees. And these are trees that are pretty far off the central portion of this property. And I'm not suggesting that they can't be removed for sure, but you know, we are talking about a charge of reasonable reconfiguration, and whether if we were going to say, hey, all right, let's say we were going to build this house from scratch, right? Would we allow it just like that?
We're gonna just continue down that
I don't believe it's
the house is there.
Yeah, I don't
You're
believe
not
it's a
rebuilding
reasonable
the house.
reconfiguration.
Every configuration I look at from this thing, I can't reasonably
I
come
can't-
up with any
I
way to
can't
do
either.
this. To put
Do
a
we have an
garage en suite.
obligation to preserve the garage?
Well, so one of the things that we and it might have been under the old tree code, but was whether, you know, it would, the redesign would affect the flow and function of the house. And so when I think of reasonable reconfiguration, that's what I think of. And I've heard from the experts here on the board that shifting the location of this would affect the flow and the function of this home. Now, that said, if we were under the old criteria, I don't know that this would be approved because this is a very large lot. It's RS 50 but the lot itself is 70 feet wide. And you know, it's got a huge backyard, but I think under the current criteria, which is this reasonable reconfiguration, I think that there's a pretty good argument that it cannot be reasonably reconfigured.
I agree with that. I agree with that.
I'm an architect, I'm not gonna redesign it, I'm not gonna say, but I think there are plenty of other ways to do this. This is a huge lot, and you know, people who say, nope, there's no other way, I'm of the opinion that that is not true.
Well, and I think reasonable minds can disagree as to what the definition of reasonable reconfiguration is. And it sounds like maybe that's what we have here. So, you know, with that said, does anybody want to make a motion?
I'll make a motion. Let's see. All right, I move that variance request for the case VRB 2355, located at 2802 West Bay Avenue, be granted as depicted on the site plan presented to the public hearing for removal of grand two oaks based upon the petitioner meeting the burden of proof with regard to the 6 factors determining the tree removal as set forth in section 27-28425 of the city code for granting tree removal. Specifically, the evidence provided in the record showed that there is not a practical reconfiguration of how to make this and mess up the flow of the house to be able to put a garage and ensuite on the first floor. Unfortunately, had to remove these beautiful trees.
Right. Motion by Mr.
Second.
Betts, seconded by Mr. Fry. All those in favor say aye.
Aye.
All those opposed?
Aye.
All right. Your variance is approved 4-2.
Thank you.
All right. With that, I'm going to close the public hearing.
Whew.